May I please, Malad? Malad, I pray for listing upon criminal petition for motion, Malad. On Monday, Malad, if possible, Malad. Obliged.
May I please, Lordship? My Lord, this matter was listed on 20th of this month. One matter, Lordship, BA, Lordship, listed on 20th of this month, Lordship, for BA. CD is here, Lordship. I prayed for listing the matter this week, Lordship, but unfortunately, the matter is listed after vacation. Petitioner is behind the bar, Lordship. After vacation without fix, I have filed an IA, Lordship. I am filed an IA, Lordship, seeking listing because my elder brothers. Yes, today, Lordship. Lordship, BA is required to be heard. My obliged.
May I please, Lordship? I beg to mention item number 4 of today's list of Honorable Court number 14. Similar matter is fixed on 13/9/2024. 30 Monday, next Monday. And kindly list this matter.
I don't know.
4.
Motion.
Kindly list the matter 11.
4 is not there. 4 at 9.
Made please, Lordship. My Lord, I beg to mention item number 20, my Lord. 20, my Lord. Motion kindly matter may be passable for the. Yes, my Lord. Yes, my Lord. Kindly passable for the day, my Lord. Yes, Rahman. Oh, no, my Lord. Kindly fixed on 1st of October. 1st of October, my Lord. My Lord, kindly motion matter, my Lord. Kindly fast. Yes, my Lord. 1st of October, my Lord. Obliged.
May I please, Your Lordship? In the item number 40, we have filed an affidavit in reply yesterday itself, and the council humbly requests you to tag the same with the main record today.
May I please, my Lord, with the consent of the learned Petition, my Lord, I beg to mention item number 53 of court number 14, my Lord. Mr. K.V. Patel has been appointed. Yes, ma'am. Yes, ma'am. Obliged, my Lord. 53, my Lord. Mr. K.V. Patel has been appointed as Amicus curiae in this matter. He is unwell today, my Lord. Let me fix it any date after 53. Unwell. Yes, ma'am. After vacation, any date, my Lord.
With due respect, my Lord, I beg to mention item number 17, my Lord. Possible for the day, my Lord. As per instruction of the Senior Counsel, Mr. Amicus Chaudhary, my Lord. Release the matter on Monday, my Lord, 30. 17, please. A. Dr. my Lord. On behalf of Mr. Amicus Chaudhary. Yes, my Lord. My Lord, out of A. Dr. my Lord. Highly obliged.
May I please, Your Lordship? I beg to mention item number 40 of court number 14. I have taken the consent from the other side. Can you? It's of court number.
May I please, Lordship, for listing on next week, Lordship, any date.
Please, Lordship. I beg to mention item number 32, my Lord, of 32 of court number 14, my Lord. CD was not received, my Lord. CD. No. AK Das, my Lord.
My Lord, I am requesting to list this matter for motion, my Lord. Obliged, my Lord.
Maybe for listing next week, my Lord. As a pair for listing next week, my Lord. Obliged.
On item number 32, interim is there, my Lord.
$54, my lord. Because my lord, the city was called for and fixed on 9th of December, my lord. Although the case was moved on 23 of this month. Yes. Yeah, I'm Hussein, my lord. My lord, liberty may be given. My lord, liberty may be obliged.
May I please illustrate? Yes. M. Islam. Islam. Yes. Very good.
Yes, Lord. Yes, Islam, I am appearing on behalf of SK Malangi. Islam. Yes. With the liberty, Lord. Obliged.
May I please take your lordship? Your lordship, 483 application, your lordship. FIR dated 21 August 2024, page number 12. Lordship.
My lord, this is from my lord Polton Bazaar. On 4th, I'll try. 4th.
Deeply obliged.
May it please your lordship. My lord, FIR, my lord, is at page number 9, my lord. Allegation. My lord, and two connected petitions are fixed on 3rd, my lord. CD, man.
Around.
Highly obliged, man.
My lord, CD, my lord. Stealing of vehicle. On 4th, my lord. Oh.
Five and 6 may be taken up together. Same person connected matter.
On Roha, 4th, my lord.
All right.
May it please your lordship, my lord, it's a my lord, here, my lord, only thing, my lord, sees a television reporter, my lord. And my lord, here,
My lord.
and the
Next
other
week.
person already on interim bail, my lord, the other person.
Next. On 4th, my lord.
My lord. Obliged. my lord.
Yes, my lord. My lord, in this case, my lord, this petition was preferred against the my lord judgment and order passed by the my lord learned additional session judge Amin Gao, whereby he in a criminal appeal, my lord, whereby he affirmed the judgment and order passed by the my lord learned chief judicial magistrate Kamrup Amin Gao, whereby the petitioner has been my lord. Whereby, my lord, the petitioner has been directed to pay rupees as a fine, rupees 90,000, or in default, 3 months, my lord, simply imprisonment. My lord, it was all, I have a prayer also, my lord. The order may be stayed. She is a my lord, no, my lord. Otherwise, she will be, my lord, behind the bar, my lord. My lord. She will be behind the bar, my lord. My lord, please, my lord. 13, my lord. Annexure A, my lord. Judgment is 15, my lord.
Related, that's not. Judgment for
Judgment
55 page.
15,
Property
15.
portion. Property portion.
15 not say to the read to main judgment.
Maze 50. File vote.
Only 45,000, my lord. And that too, my lord, that too, my lord. It is admitted by the response number 2 that he has not given any money to the my lord petitioner, my lord. My lord, kindly turn to page, my lord, 28, para 32. My lord, admission, my lord.
Judgment or reflect
Judgment, policy. Yes, my lord. There is in page 16, my lord. This is the first one. During the course of trial, the complaint side, she stated that she did not take any money from the complainant and she did not issue any check. No, my lord. There is, my lord. He has admitted, my lord.
303 is not evidence.
My lord. I'm showing, my lord. My lord. Yes, my lord. Yes, I'm showing, my lord. It is reflected, my lord, in the judgment, my lord. I'm just. My lord, kindly turn to page 17, my lord. Para 7, my lord. In course of his, may I read, my lord? In course of his cross-examination, PW1 stated, PW1 is the response number 2, my lord, stated inter alia that he has known the accused person since long. He gave rupees 50,000 to Sri Krishna Das. I am not Krishna Das, my lord, who executed a hand note at the time of taking money. PW further one stated that he did not pay any money to anyone else.
Krishna Das is her husband.
Husband, my lord. My lord.
My lord.
Anyone else? Yes, my lord. It is admitted, my lord. Nine, my lord. NS Thakuria.
D Das.
PW 1, respond number 2. My lord.
Where was that?
My lord, kindly turn to page 17, my lord. Para 7.
Page 17.
Yes, my lord. Para 7.
PW1 testified that he did not pay any money to the accused petitioner. Stop. In view of the aforesaid testimony, she further submits that the judgment of the trial court and the appellate court warrants interference is totally erroneous. Stop. The petitioner accused has prima facie made out a case for interim. Accordingly, in the interest of justice, in the interim, it is directed that the operation of the judgment and order dated 25/6/2024 passed by the learned additional session judge Kamrul Amingao in criminal appeal number 12 of 2023 shall remain state till the next date.
Deeply obliged, ma'am.
Next day, this one will be placed after 4 weeks. 4 weeks, after 4 weeks, and it will be fixed by the registry. Yes.
May I present? This is a case arising out of a complaint petition under 138 NI.
Yes.
Learned trial court convicted me and sentenced me for simple imprisonment for 1 year and sum of rupees 5 lakh. Therefore, I went for appeal. The learned session judge upheld the conviction, and the sentence is modified that 1 year imprisonment has been deleted. Only I was
fine is there.
Only fine is there. Against it, I'm agreed. I'm here. Now, the basic contentions before this honorable court, which I want to raise, my lord, for drawing up the presumption under 118 and 139 of the NI Act. Before that, my lord, the complainant has to prove the foundational facts. And there are basic two defects, my lord, in his foundational facts, which he could not discharge. And therefore, I'm here before your lordship. Lordship may kindly peruse the complaint.
1 second. Yes.
Complaint is page 17, my lord.
Yes.
My lord, second paragraph, relevant.
Yes.
Complainant and accused have business and friendly relationship. By dint of such relationship, accused person took rupees 2,90,000 in August 2013.
Now the appeal court has modified it and has only kept the fine.
Yes.
Fine is how much?
5 lakh.
Huh?
5 lakh.
5 lakh.
5 lakh.
Where
Now-
is the appellate court's order?
That is.
You have challenged the appellate court's order.
Yes, yes. Basically.
Where is it?
It starts from page 69, operative portion page 86.
Yes.
Now the operative portion, my lordship would see the sentence imposed, the conviction is affirmed, the sentence imposed by the appellant is modified, and the appellant is convicted and sentenced under section so and so to pay a fine out in the form of rupees 5 lakh.
18, it starts the relevant findings.
Yes, ma'am.
Yes, what is wrong in this order?
My lord.
What is wrong in this order?
My lord.
What is the manifest error in this order?
My lord, two things. My lord.
First of all, in the complaint, nowhere he has stated on which date he has given me the money, which is very relevant, my lord.
Sorry,
Secondly, my lord.
I'll issue notice, but
My lord, I'll satisfy, my lord. I'll satisfy, my lord. Because there is a judgment in my support of the Supreme Court. On which date he has given me the money. Secondly, he says that in cross-examination of my cross-examination, he puts one question that he has given me in by way of check.
Which has to be examined.
No, Lordship, I will indicate very shortly, my lord.
Yes, yes.
He has put in a question that he has given me the money by way of check, but in his cross of PW1, he says that in the ITR return, those transactions are not there.
I can issue the notice on the interim and keep it open.
But if it is executed, I'll be put behind the bars. I have to pay the entire 5 lakh rupees. There are basic defects. Lordship, kindly go through this judgment. My lord, this is
What is the judgment you want to rely on?
This is 2014 2 SCC 236.
Because unless I'm convinced there is a manifest error, you will not be getting a stay.
Lordship would also find in cross of PW1.
1 second. In this case, you are relying in paragraph?
Paragraph 6. There the defects found out by the trial court. It says paragraph 6 6.1.
Vital defects.
Yes, vital defects. Though the respondent as PW1 deposed that the accused received the money at his house, also stated that he did not remember the date when the said sum of rupees 1,50,550 was paid to him. 6.2. As regards the source of advancing, that I am not urging regarding the source. 6.3. In course of cross-examination, the respondent stated that the check was signed on the date when the payment was made. Nevertheless, he stated that he was not aware of the date when he paid the sum of rupees 1,50,000. 6.4. According to the respondent, the check was in the handwriting of the accused himself. And the very next moment, he made a contradictory statement that the check was not in the handwriting of the appellant and that he wrote the same. Now, in the instant case, what happened, my lord? He says that the writings in the check was written by some Prabhat Barua. Then it's no, it was not Prabhat Barua, it was written by me. So these are serious defects which your lordship I have pointed out. Yes, that the cross of PW1.
Where? Page?
Page, it starts from page 23. That page 25 is the relevant portion.
Yes.
Towards the last, my lord. Should I read the entire?
Yes, yes.
Yes.
No, which one?
I want to
draw the notice of this court to that particular point.
Towards the later part, the last part.
Yes.
The words 2,90,000 as appearing in Exhibit 3 were written by my accomplice Prabhat Barua. The words Sagar two-wheeler appearing in service center and the amount appearing in Exhibit 1 were written by Prabhat Barua. Later on said the contents of Exhibit 1 were written by me. These are serious contradictions, my lord. Therefore,
and the date,
my lord, lordship, I have already shown page 17.
This is the evidence of?
This is the evidence of PW1, the complainant.
Complainant.
Page 17 is the complaint.
Yes.
Second paragraph. Complainant and so-and-so are good in relation. By dint of the relationship, accused person took rupees so-and-so in August 2013. There is no mention of date, my lord.
No specific date.
No specific date.
All right.
And even in 145 also, his depositions, he narrated the same thing. No date. That is page 23, paragraph 2. I have a business.
August 2013.
Yes. No
All right.
specific date.
Yes, Mr. Das.
We are formal party, and even then, concurrent finding is there.
He is making out a case that is, it appears it is only as regards the fine now.
Now, my learned friend has pointed out some contradictions
Defects.
during cross-examination.
Correct.
Now, whether these are fatal or not, my lord, that has to be examined.
Anyway, matter needs examination.
My lord.
Mr.
A.
Heard
Bhattacharya.
Mr. A. Bhattacharya, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for the state respondent. Stop. By way of this petition under section 438442 of BNSS Act 2023, challenging the Act BNSS 2023, whereby the petitioner is assailing the judgment and order dated 29/6/2024 passed by the learned additional session judge Sibsagar in criminal appeal number 68 within bracket 4 of 2017, as well as the impugned judgment and order dated 27/11/2017 passed by the learned subdivisional judicial magistrate. Stop. Mr. Bhattacharya submits that the appellate court by the aforesaid by the said judgment and order dated 29/6/2024 partly allowed the appeal, and while affirming the conviction of the petitioner under section 138 of the NI Act, he was sentenced under section 138 of the NI Act to pay a fine in the form of compensation amounting to rupees 5 lakhs only in default to simple imprisonment for 3 months. Stop. Issue notice returnable 4 weeks. Mr. Didas accepts for 1, registered steps 2, and steps within 3 days, extra copies within 3, and steps within 3 days. Then, in support of the, it appears from the FIR and the testimony of the complainant that the complainant has not given the specific date on which the check was
money was advanced
on which the money was advanced to the accused petitioner. Stop. It further appears that during cross-examination also that during his during cross-examination, he have the complainant has specifically clarified that the money was. What is this exhibit 1?
Exhibit 1 is the check.
That the check in question was written by one Prabhat Borua. However, later on, he says that it was written by him. Stop. Prima facie, it appears that there are defects as regards the consistency of the version of the complainant. Stop. Accordingly, in the interest of justice, in the interim,
page 15.
It is directed that the operation of the judgment and order dated 29/6/2024 passed by the learned additional session judge Sibsagar in criminal appeal number 68/4 of 2017 shall remain stayed till the next date of listing.
I may be allowed to remain on previous page.
And the petitioner may be allowed to remain on previous page.
Much obliged.
May it please the Lordship. My Lord,
Yes.
this is criminal revision, my Lord. I was convicted under section 352 and 354 of the IPC for a conviction of 1 year, 1,000 fine, and in default for another 15 days. Now, I go for appeal. Appeal was upheld, my Lord. Now, my Lord, my challenge is basically on two folds. The first is, my Lord, there were a bunch of contradictions which were never taken into account. Bunch of contradictions between the witnesses, including the informant. And the second fold is there were certain major omissions which the informant and the witnesses ought to have told to the IO, but it was never told. And it was brought on record during the cross-examination of the investigating officer. My lord, the victim states that after closing a shop at around in the evening, when she goes to her home, my lord, the someone came from behind a tree and started assaulting her. And only after PW4, who was riding a motorcycle, came by, from the flash of the light, she could identify the witness, the petitioner. Meaning thereby, my lord, it was a pitch dark. And now PW5 states that the victim and himself, both of them, they close the shop together nearby, then they head towards their respective houses, which are in the opposite direction. After he walks for a while, he hears a scream of the informant, the victim. He rushes and he says that there was no one there in the vicinity, and he saw the petitioner assaulting the victim. My lord, now this is a major contradiction because she herself couldn't identify before the bike came, and only after the flash of the light she could.
Who has identified?
My lord,
who has identified?
PW5.
Who is PW5?
PW5 is a shopkeeper who has a shop nearby the victim.
And so, what is inconsistency about that?
Yes,
maybe the victim has not seen.
My lord,
maybe the victim has not seen. The shopkeeper has seen.
my lord,
What
now.
is wrong?
My lord, when I am assaulting someone, I have to be very nearby. When the victim,
These
in
are
fact,
matter of appreciation,
and my lord,
reappreciation, Mr. Bora.
my lord,
these are matters of appreciation, reappreciation.
yes.
At this stage,
and my lord,
this is the
this
revision
fact,
petition.
and my lord, this
You
fact,
have to show what is the manifest error.
yes, the manifest error, my lord. I'll come one by one. My lord. These facts were never told to the IO, to the investigating officer. That yes, only when PW5 came riding the motorcycle, I could identify. That's number one. Number two is that alleged blouse which was torn. Now this blouse was never exhibited before the court, but the court comes to finding that yes, only because the victim has said that it's a red blouse, yes, takes into account.
That
Whereas,
will not make it fatal.
Whereas, my lord, the victim herself told to PW2 that PW2 tells to the court that yes, the victim has told me that the blouse was yellowish. However, it was discarded.
Where is that?
My lord,
there is a discrepancy about the color.
Yes, and
Where?
it was never taken. Yes, my lord.
And the blouse was not seized.
It was seized but never exhibited.
It was not exhibited.
It was never exhibited. Whereas, and PW2 was negated on the point that it's a hearsay evidence. Well, this is. Can I take your lordship directly to PW2?
Yes.
PW1 is the informant. PW2 for a while moment.
Yes.
May I start with that?
Yes.
I know the informant as a house is about a
kilometer.
kilometer.
I don't think everything is important.
Not important.
You have already underlined the relevant portion.
Yeah.
She had also shown me a torn yellowish white blouse.
Yes.
Yellowish white blouse.
Yes. And this particular witness was discarded on the point that he's a hearsay evidence. However, my contention is no. Section 6 of the Evidence Act clearly says, although the fact is not an issue, but it's so deeply connected that it becomes a fact in issue. Now, the informant herself told to PW2 that this is the blouse and
where
this
is the informant's
PW1. PW1.
Where is the red?
May I read? Thereafter, he physically assaulted me. He had also torn the blouse.
Where are you reading?
The first page.
Yes.
Below.
Yes.
There's a slang. Yeah. Thereafter, he physically assaulted me. He also torn the blouse worn by me and assaulted me with his hand. I got injuries on my back and on my chest. When the accused person was assaulting me at the time, this is very important. At that time, a bike came, and in the light of the bike, I saw the accused person. Thereafter, I called my son-in-law so-and-so over phone, and he arrived in 10 minutes. At that time, the accused person was present. Sahadat, now this is important. Sahadat, who rode the bike, was also present, and another person I do not know know his name, was also present. Thereafter, people gathered there and took me away, and I went to the so-and-so, and I lodged the.
Where is the red blouse?
Milord?
Where is the red blouse?
The blouse, yes. Yeah, the police is the examination chief below.
Yes, police did not seize my
my red blouse.
Where?
Not just before the cross-examination, second page, just above the cross-examination.
Police sees my red blouse.
Yes. Now, may I draw your lordship's attention?
Now, what about the Caesar list? It says red or white?
Caesar says red. Caesar says
says
red.
red.
Caesar says red. But it was never. Now, my lord, for a while, may I draw your lordship's attention to PW4?
Mr. Bora,
PW4.
manifest error.
For a while.
I cannot. I am not exercising the powers of an appellate
I understand.
court.
I understand. I understand.
Please understand the limitation.
I understand. Then your lordship may I draw your lordship attention to ID investigating officer.
Yes, page.
PW7. The cross examination.
Yes.
The cross examination.
Yes.
I received the Ejahar so I went to the place of occurrence on the same day. I recorded a statement of all the witnesses. I prepared a sketch map at the place of occurrence. I have not written at the time of the sketch map. There is a format so the case is filled up in the sketch map. I have mentioned the road leads to. I have not met Ainul Haq at his house, and I have not mentioned the place of occurrence. The complainant, this is important. The complainant had not stated before me that the accused person came out from behind a tree at the night and assaulted me on his back. The complainant did not state before me that the accused person took a step and when the bike came.
So 161, this were not said.
Not stated. Not stated. The complainant stated before me that before the incident, the accused used to verbally assault me. The complaint
So
also
nothing
did
has
not.
been said.
Huh?
Nothing has been said in 161.
No. These are major omissions. These are major omissions which can be taken as a contradiction law. The complainant also did not state that incident when he called us son-in-law. The complainant also did not state that she recognized the accused in the light of the bike. Also did not mention that the accused
Mr.
fled.
Das.
There's an IA for
Mr.
suspension.
J. Bora. Huh?
There's an IA for suspension of the sentencing.
No, you are seeking the stay where? In the criminal revision?
No, my lord, in the IA. In the IA.
In the
IA.
Then the IA can be disposed of.
And my lord, in the revision, the records may be called for.
One by one, Mr.
Yes,
Bora. Heard Mr. J. Bora, learned counsel for the applicant. Stop. Also heard Mr. D. Das, learned APP for the state respondent. Stop. By way of this interlocutory application under section 438 of BNSS 2023, the petitioner is seeking suspension of sentence and realization of fine. In respect of judgment and order dated 6/9/2024, passed by the learned Additional Session Judge Borpeta, whereby the learned appellate court had dismissed the appeal, being criminal appeal number 14 of 2024, and uphold the judgment and order dated 13/5/2024, passed by the learned Judicial Magistrate First Class Borpeta in PRC case number 279 of 2021, convicting the appellant under sections 352, 354 of the IPC, whereby the applicant was sentenced to undergo simple imprisonment for 1 year and to pay a fine of ₹1,000, and in default to undergo simple imprisonment for another 15 days. Stop. In support of the prayer made in the interlocutory application, Mr. J. Bora draws the attention of the court to the testimonies of the prosecution witnesses, especially to PW1, PW2, and PW7 within bracket, the investigating officer, to contend that there are inconsistencies apparent on the face of it. Stop. Mr. D. Bora, Mr. D. Das, learned APP, on the other hand, submits fairly submits that he has received no instructions to oppose the prayer made in the interlocutory application. Stop. I have heard and perused. It appears from the evidence of PW5 within bracket IO that the PW1 is the
Seven,
complainant.
seven. PW7
7.
IO. IO is PW7, my lord.
Oh, sorry. PW7 that the complainant has not maintained her version, has not maintained the version as regards the accounting of the incident consistent from the stage of filing the FIR till giving testimony in before the court. As such, the applicant has made out a case for suspension of the judgment and order dated of the appellate court. Accordingly, it is directed that accordingly this court directs us directs that the which is the appeal, the order you have. Why in the prayer you have not mentioned all this?
My lord.
Why have you not mentioned it in
When
the
on page
prayer?
6, the appeal number is appeal criminal appeal 14, page 6.
Anyway, that appeal is dated
6-9.
6-9, right?
Yes. 6-9.
It is directed that the impugned judgment and order dated 6/9/2024 passed by the learned additional session judge Borpeta be stayed till disposal of the connected revision petition, and the applicant is allowed to be remained on previous bail till then. Accordingly, the interlocutory application is disposed of. In the main criminal revision heard data side queryba, this application is under 442 of BNSS 2023 assailing judgment and order dated 6/9/2024 passed by solicitor. Issue notice returnable 4 weeks. Mr. Das accepts notice R1 extra copies, registered post AD 2, and call for records from the appellate court. Appellate court.
Additional session judge.
Within bracket,
Borpeta.
additional session judge Borpeta. List after 4 weeks on a date to be fixed by the registry.
Deep problem.
Take this back, Mr. Boram.
Yeah.
Let it be, Mr. Boram. Ujjwal, okomandi rakha. I will need it while I'm editing the order, so you take it back after the break.
May I please allow?
Yes.
The concurrent findings, my conviction under section 419 of the IPC and sentenced to 2 years simple imprisonment.
419?
419. Then cheating by impersonation. And
Impersonation.
Yes, ma'am.
Yes.
Sentence is for 2 years, my lord.
What is the manifest error?
No, my lord. On other note, my lord. On other note, my lord.
On other note?
Yes. On 419 is a bailable section, and the sentence is less than 3 years. So, my lord, as such, my lord, I pray that the petitioner may be allowed to remain on previous bail, my lord, and the records may be called for, my lord. As if I may place a section, my lord, before your honor.
One second. Where is a prayer here?
My lord, prayer. Prayer, page 11 onwards, my lord. Okay.
Your sentence is how much?
Sentence is 2 years. That's less than 3 years, man. 389.
All right, he was already on bail. Heard, Mr.
PK Munir.
PK Munir, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for the state respondent. By way of this revision application under section 438, read with 442 of the BNSS 2023, the petitioner is assailing the impugned judgment and order dated 30/7/2024 passed by the Court of Learned Additional Sessions Judge Sipsagar in criminal appeal number 56 within bracket 4 of 2017. whereby the judgment of the learned Assistant Session Judge Sipsagar dated 14/9/2017 passed in session case number 18 within bracket S-N 2016, convicting the petitioner thereof and sentenced to suffer simple imprisonment for 2 years and fine of rupees 5,000 was upheld. Convicting the petitioner thereof Nokoba under section 419 of IPC. Issue notice, returnable 4 weeks. Mr. So-and-so accepts notice R1, R2 registered post. In the interim, petitioner is allowed to remain on previous bail.
Sentence maybe
Records required?
It will be required.
Call for the records from the court of
It will be, my lord, from the
Assistant Session Judge Sagar.
Yes.
List after 4 weeks and a date to be fixed by the registry.
Sentence is required to be suspended.
Till then, the suspension is also stayed. Operation of.
Much obliged.
FIR Quashing.
Lordship, my senior is Lex in another court. Lordship, may kindly pass over the matter for time being. Okay.
Please, sir.
Yes. Complaint case. Item
14, my lord.
Yes.
May I please the lodge? We have filed this petition for quashing of the proceeding of criminal case, my lord. Here, my lord, the informant, my lord, complainant, my lord, he filed a complaint.
Order dated 7/6/24.
Lordship.
Yes. This order is of taking cognizance.
Lordship.
When is the next date?
Next date, my lord. Today,
Huh?
today, my lord, itself, my lord.
No, I am issuing notice.
My lord, lordship, kindly see the complainant, my lord, he applied loan, my lord.
Your challenges to the order of 7/6/24.
As well as the entire proceeding, my lord.
Correct, but here it seems it has taken cognizance after the perusing the deposition of the complainant.
I have annexed the deposition. No, my lord, no ingredients.
Where is the deposition?
Lordship, kindly see.
Page?
Page 18 onwards, my lord.
What is the offense that it has?
Not a single, my lord, ingredients of these sections, my lord, are available either
Mr.
in the
Das,
FIR.
page 18.
Lordship.
So,
Nothing,
just
my lord.
see page 18.
And he applied for loan, my lord. The loan was refused by the
One
bank.
second.
Lordship.
I don't think any criminal case is made out on this deposition. He's taken a loan, he did not give him and refused to give. Civil remedies are open.
Main branch.
One second. When the court is
I'm
with
sorry.
you, why unnecessarily you are submitting? Yes.
Initially.
Before
See, page 18 is the deposition, and then you see at next page, Annexure 5, upon perusal of the complaint as well as initial deposition.
My lord.
The court finds sufficient grounds 409, 417, 384, 506. Isn't it? Yes, heard Mr.
R. Ali, my lord.
R. Ali, Learned Counsel for the petitioner. Stop also heard Mr. Didas, Learned APP for the state respondent. By way of this petition, under section 528 of BNSS 2023, the petitioner is seeking quashing of the entire proceeding of complaint case registered as CR case number 3362024, registered under section 409, 417, 384, 506, 34 IPC, pending before the Learned Judicial Magistrate First Class, Borpeta. Stop. Issue notice, returnable 4 weeks. Mr. Das R1, extra copies. Steps by registered post R2 within 3 days. It appears that the Court of Judicial JMC First Class Borpeta, upon perusal of the complaint as well as initial deposition of the complainant recorded under section 200 of CRPC, as well as examination of witnesses under section 202 of CRPC, took cognizance of the offences under section 409, 417, 384, 506, 34 of IPC against the petitioner. Stop. Petitioners.
Petitioner 2, my lord.
Against the petitioners. Stop. A perusal of the deposition of the complainant appears that the complainant applied for loan and it was sanctioned by the manager of the bank in question. However, when he went to take the money, the manager is the manager stroke petitioners did not give him the money and refused to give him the sanctioned loan. Stop. Prima facie, no criminal case is made out on the face of such deposition. Stop. Accordingly, further proceeding of complaint case number 336 of 2024, registered under section 409, 417, 384, 506, 34 IPC, pending before the Judicial Magistrate First Class Borpeta, shall remain stayed till the next date of listing. Records, I don't think required in this list after 4 weeks on a date to be fixed by the registry. Yes, 15. Mr. Ali.
My lord. This
420.
is lordship. Here, my lord, the FIR was filed, my lord. Then, my lord, police investigate the matter. Then, final report was submitted. First, final report submitted. Then, my lord, the court, my lord, issue notice to the informant to submit objection. He filed an objection, my lord. Matter was, my lord, sent for further investigation. And, my lord, after, my lord, further investigation, again, my lord, final form was submitted.
Again,
my lord, second time.
Then,
my lord, he filed a petition, my lord, page 39.
Who filed a petition?
The informant. Page 34. He filed an application for reinvestigation of the case.
After
second
closure.
Lordship.
Yes.
Page 34.
Yes.
Clear, my lord. It is in the premises, it became necessary to pass an order directing the IO to reinvestigate the case in a proper manner.
Yes, then?
These prayer were rejected, and without any my lord, Narazi petition or objection petition, the my lord, court registered a criminal case
No,
against
you said this was rejected?
Lordship.
Where
Page
rejected?
35. Rejected. Petition rejected.
Or the closure was rejected?
Closure was rejected.
No, my lord. The application, my lord, for further investigation.
Further investigation was
Yes, because it says the IO again submitted the FR citing the case as a mistake of fact. I have not understood. What is this, Mr.
Considering
Das?
all, the prayer for sending the case for further investigation is rejected. Then, my lord, without any application, he registered the case, my lord.
Later on.
Left. Without, my lord, any
What is it, Mr. Das? How is this
My lord.
done? Twice closure. IO has said
No,
Mistake
second,
of fact.
third time, further investigation is rejected. But even if it is rejected, the court has power, London Magistrates
But
Court
there
has
has to
power
be
to
some
register.
materials.
Yes, on the basis of that Narazi petition, that Narazi petition can be registered as complaint case.
I've understood.
That is what has been done here.
Huh?
That is what has been done.
No, but if you see on that same order, the magistrate says, considering all, the prayer for sending the case for further investigation stands rejected.
Rejected.
And
So-
after that again,
That prayer was only again further investigation. Once
That
further
was
investigation is done, second time further investigation is done, again the complainant wanted
That is
further
rejected.
investigation. That is rejected. Now his objection may be registered as complaint case. That power is given, that power has
where is that?
One.
So here the complaint, the objection has been registered.
No objection filed, my lord. Only application filed for reinvestigation. That was rejected.
No, CR put up. The case is registered as case being no iman.
If you see page 34, this is just an application for reinvestigation.
Reinvestigation.
Correct.
The third time reinvestigation is obviously not given.
Yes, but then if something is
Now we do not know whether Narazi petition, when somebody
all right, then
objection, let a notice be issued at this case, let the other side come.
okay. Heard Mr. M. Ali, learned, R. Ali, right?
Lordship.
R. Ali, learned counsel for the petitioner, stop. Also heard Mr. Didas, learned APP for the state respondent, stop. This is an application under section 528 of BNSS 2023 for quashing entire proceeding of complaint case number 96/2021, registered under section 420 406 34 IPC, pending before the learned CJM Borpeta. Issue notice returnable 4 weeks. Mr. Das accepts notice on behalf of respondent number 1, extra copies within the course of the day. Register post steps by register post AD in respect of R2 within a period of 3 days from today. Issue notice on interim list after 4 weeks on a date to be fixed by the registry.
But in the meantime, my lord, cognizance has been taken, my lord.
All right, next. FIR quashing.
Yes,
Mr. Barbhuya.
Yes, my lord. May I please, lord?
Where is the FIR? It's a 376 case.
My lord,
Just issue notice. Just issue notice.
Please, Malaka. But in this matter, it's a CBI registered an FIR against me. Originally saying that at 2 p.m. on.
What is this? You are seeking quashing of the charge sheet?
FIR and charge sheet both.
Okay.
But can I have a look at first the FIR itself?
Yes, where is it?
It's annexure P1. No?
Annexure?
P1.
Page.
Page would be 142.
Yes.
Just have a look at the first page only.
What do you want to show from the first page?
Para 3, man.
Yes.
Its date of registration is 12 June 2022 at 14 hours, and the place is CBI AC1 New Delhi. So
Yes.
FIR registered there, and if you skip a few pages and go to the end of it, it was entrusted for investigation to the IU at Delhi only. If you will see, kindly come to page number 151.
Yes.
You will find para 13. Para 13 within column 2, Shri Arjun Kumar Maurya. Page number is 151.
Yes, Inspector of Delhi. Yes.
Please. Now, what happened thereafter is very peculiar.
We'll come to 145. Let's see the contents.
Please, ma'am. 145 is on the.
145.
I'll read it. Information received from reliable source reveals that National Highway Authority of India under.
1 second.
Please.
Special PP, Mr. M. Holloway for CPI. He is on late. Code number 1.
After some time. None appears for the petitioner when the matter is called. List after 2 weeks on a date to be fixed by the registrar.
I please your lordship.
FIR question.
Lordship. Now here, lordship, before I take the lordship, here I will be pressing too much today for one of the petitioners. For the petitioner, she is a government employee, lordship.
Where is the FIR?
Yes, lordship will kindly come to the impugned FIR that is in annexure number 6, lordship.
Page
45. 45.
Yes.
Lordship may kindly see, I am a lady and against me, FIR has been registered under 312 and 420. So lordship has kindly got it, lordship. It is in column number 2. So 312 lordship says, causing miscarriage. Whoever voluntarily causes a woman with a child to miscarry shall, if the miscarriage be not caused in good faith, for the purpose of saving the life of the woman, be punished with an imprisonment of either description for a term which may extend to 3 years. So therefore, one thing is clear, lordship.
What about 420?
Yeah, I'm coming to that, lordship. Against a woman, 312 will not be attracted. Now, lordship may kindly see the ingredients in the FIR, whether it makes out a case of 420.
Yes, where do I find
page 49, lordship? May I read the FIR?
Yes.
Now, here, the informant is my husband.
Yes.
And lordship, there are matrimonial disputes going on. That is the background which led to the lodging of this FIR. Most respectfully, I beg to state that I had solemnized my marriage with one Priyanka Theron. That is myself, one of the petitioner, lordship. The daughter of late Dhiren Theron before the marriage officer Kamrup Guwahati so-and-so. Soon after the marriage, we started our conjugal life, but very surprisingly, it was observed that she had lost interest upon me after a lapse of about 10 to 11 months. Our conjugal life, she left my house without any reason and lost the desire upon me. That is, I first lodged an FIR. So this is the retaliation of the FIR being lodged by me.
Continue reading.
Lordship, I am reading, lordship. My family members on 11/11/2019, in which charge sheet has been submitted by the police, and the same is pending in PRC 75/2020 at the Court of Honorable Special Judge. So I am coming to the contention made by him to make up a case of 420. Lordship, kindly see page 50. It starts from here. When my parents went to the house of Amar Rohang, along with the accused number 2, to know the reason of such act, then we came to know about their relationship. In fact, Amar Rohang said that some of the belongings of the accused number 1 is still with him, and further he also stated that the accused number 1 has married the informant only to grab the money. So he says that I had relationship with earlier other persons which I have not revealed during our conjugal relationship, and therefore I have cheated.
What case is made out, Mr.
Yes.
Bora?
Now, lordship will kindly see.
Let him submit my lord after that.
Okay. Now, lordship may kindly see. Police after investigation, police submitted an FIR. Page 55, lordship.
1 second, we'll go one by one.
Lordship.
Those two offences that has been booked is
312
312 and 420.
Now 312, lordship will perhaps not be attracted against me, I being a lady. Now
420, where is the initial deception, inducement,
absolutely, lordship.
delivery?
I'm on that, lordship. I'm absolutely on that.
Yeah, IPC. Football IPC. Yes, Mr. Bora, what do you want to say?
And it is fast.
Oh, I'll come back in 5 minutes.
My lord. That in final report room. That means there is no case, my lord. After that, my lord, the informant, my lord, who is the husband of
the FIR ultimately closure report.
Closed, my lord. It is closed as a final report, my lord. That means, my lord, there is no case, no evidence has been found, my lord, or no cases has been found against the, my lord, incident or against the, my lord, occurrence, my lord. That is why final report has been submitted, lordship. After that, lordship, the petitioner, my lord, he has, my lord, filed this Naraji application, my lord.
Investigation against him.
To my lord, do further investigation, my lordship. Now, lordship, what is the order, my lord? That, my lord, that further investigation has been allowed. Now, this prayer, my lord, lordship, kindly
already started. I
where is
regularly
it?
called.
where it is, my
Where
lord.
is it?
Kindly see his prayer, my lord, for passing the FIR, my lord.
Where is all that? Those has to be brought. That is the order which has to be quashed by this court. If the
Exactly.
order is not placed
Lordship,
before this
Lordship, I will
court,
come
how
back.
can this court quash
I will
it?
come back, Lordship. I will come back. I will come back.
You should have told before, Mr. Barwa. I wouldn't have invested money. In fact,
prepared and
inside
drafted by
also I
somebody
was
else.
thinking the.
I am also sorry, prepared and drafted by somebody else. Lordship.
Anyway,
I will come back.
yeah,
I'll come back with that.
24 now. You're Mr. Bhattacharya.
A. Bhattacharya.
As prayed for by Mr. A. Bhattacharya, list this matter after
vacation.
2 weeks on a date to be fixed by the registry to enable the petitioner to file additional affidavit.
Deeply obliged.
25. May please, Your Lordship.
This is an anticipatory bail.
My Lord.
Yes.
Lord, this is charge-sheeted case, Your Lordship. Lord, charge sheet has been submitted showing the petitioner to be absconder, Your Lordship. So now the petitioner is
All right,
apprehending.
then CD.
No, it's not required, my Lord. Actually, my Lord, the trial court, my Lord, issued summon, my Lord. What normally does, my Lord, trial court. Then also he has not appeared, my
So
Lord.
let him appear.
Let him appear, my Lord. No need to.
You appear before the trial court.
Trial court may be directed to release him on bail, my Lord.
No, that the trial court will consider
consider
on your
my-
appearance.
Deputy
Why should
Lordship.
this court dictate what the trial court should do?
Lordship may kindly
You
come
have
to, my Lord.
received summons, you are not appearing, you are absconding.
No.
You appear before the trial court and
My Lord.
hmm?
My Lordship may kindly come to page number 25, my Lord. Last page, my Lord. Lordship may come to down portion, my Lord. Issue bailable warrant, my Lord.
No,
When
nothing.
bailable warrant is issued, my Lord,
Nothing
that
will.
means he is entitled to go for bail, my
Yes, are you
Lord.
appearing before the trial court? Then I can dispose it of.
My Lord, I am ready to face the trial, Your Lord.
25, huh? Heard, Mr.
A. Rahman.
A.
A. Rahman.
A. Rahman, learned counsel for the petitioner. Stop. Also heard Mr. R.J. Borwa.
R.J. Borwa, J.
R.J. Borwa, learned APP for the state respondent.
Next date is fixed on 23.
This is an application under section 482 of BNSS 2023 for granting pre-arrest bail to the accused petitioner in connection, who is apprehending arrest in connection with PRC case number 149 of 2024 arising out of Goripur PS case number 1277 of 2022. It appears that trial has already commenced and the trial court by order dated 25/7/2024 has issued bailable warrant of rupees 1,000 against the petitioner. Right?
My Lord.
Stop. Today, when the matter was called, Mr. A. Rahman submits that he has instructions that the petitioner is ready to face the trial. Stop. In view of the aforesaid endorsement, this criminal petition stands disposed of with a direction to the petitioner to appear before the trial court
On the next date fixed.
on the next date, i.e. 24/9/2024.
Now 23/12/24.
23
12 December.
on the next date 23/12/2024, and upon such appearance the trial court shall proceed in accordance with law. Correct, Mr. Bora?
My Lord, correct.
Stop. That's all, nothing else. I don't think anything is required.
He will not be put, my Lord, because it's a bailable warrant, my Lord.
Yes.
Charge-sheeted tax.
Disposed of.
Obliged, Your Lord.
Lordship, this is also charge-sheeted matter, Lordship.
Where is the order? Next date is when?
Lordship, charge-sheet, Lordship, annexed to page number 15, Lordship.
When you appear,
Lordship,
Summon issued, my Lord.
Summon. We are ready to appear before your learned trial court, Lordship.
where is the summon?
No, order may be perused, my lord.
Where? Page?
Page
27.
Page?
27 looks. And accept 3. Lordship, page 28, last order 25,
Yes, you
7.
appear.
Lordship, we are ready to appear before learned trial for Lordship. Direction may be given to appear.
What directions you need? But anyway, heard Mr. N. Alam, RK. Stop for the learned counsel for the petitioner. Stop. Also heard Mr. R.J. Barwa, learned in APP for the state respondent. This is an application under section 482 of BNSS 2023 for granting pre-arrest bail to the accused petitioner who is apprehending arrest in connection with PRC case number 96 of 2024, within bracket, arising out of Gauripur PS case number 105 of 2019. Stop. Mr. N. Alam RK, learned counsel for the petitioner, submit that that he has received instructions from his client, from the petitioners, that they are ready to appear and face the trial.
And accordingly, we are learned trial could be allowed to go on bail.
In view of the aforesaid endorsement, this anticipatory bail application stands disposed of with direction to the petitioners to appear before the trial court on the next date,
24/10/2024,
and on such appearance, the trial court shall proceed in accordance with law. Disposed of.
May it please, Lordship. Lordship, can the matter be taken up on Monday, Lordship?
As prayed for, let this matter on Monday.
Obliged, Lordship.
This is Quashing for me.
Yes.
SJR and as well as substitute.
FIR as well as charge sheet.
Yes, substitute and as well.
Where is the FIR?
FIR at page Alexa 4.
Yes. Please read.
Lordship will get a type copy in page 31.
You are the owner.
I am the owner, my lord. Interesting, my lord, a lot of civil cases are there. And he lost the civil case in all the forums, including High Court also. Then all the time he has the owner of the restaurants, he has a mood to involve in all quarrels. And the time sometimes he involve herself for that claims and counter claims of the criminal case also there. Subsequently, the manager, by way of involving the manager, finally as heard that the entrance, going to their restaurant, actually as per the agreement, there is no provision for any parking within the campus of the landlord's property.
But let's see the FIR, because you are seeking for quashing.
Yes, ma'am.
So
but here it is specifically mentioned in the FIR as that there is a lot of civil case also there. So whenever civil case is there, they pressurize to put the landlord.
True, but you see, otherwise the ingredients appears to be there on the face of the FIR, right?
Yes.
Now, charge has also been framed.
Charge not framed, my lord.
Charge not framed.
Charge not framed.
So, if suppose there is nothing after the investigation, you can always be discharged. Why should this court at this stage? Anyway, today it has come for motion.
Yes, motion. I prayed, my lord, that should be PRC may be stayed, my lord.
No.
Notice may be issued, my lord. Notice may be issued.
Notice I will issue. There is no difficulty. But this is not a case of
No, my lord, this is a clear case, my lord. My lord,
you see, Mr. Counsel,
my lord,
powers of quashing.
My
We
lord,
did not go into the depth of it, correct? From Bhajan Lal, everything is very reiterated time and time. And these are very the discretion of the court, which has to be exercised with
that is
caution
why
and
7
care.
categories are there, my lord.
Correct.
I am
Now,
claiming the category number 1, 7, and 4.
According to you, this is because of the grudge.
Grudge and in the prima facie, my lordship, my lord, if the content of the FIR is taken in entirety, it will not disclose any prima facie case. And moreover, the charge sheet has been filed by the ASI. As per the provision of CRPC 161 and the Police Manual 36C, the below the rank of the SI charge sheet cannot be filed. The law point also will not be discussed. An Indian Oil Corporation case in the Supreme Court already decided that whenever anything
Civil.
My lord?
Civil.
Yes, my lord. Then whenever something is to be settled by a civil or in dispute, not encompassing
Yes,
any
but
criminal.
here the criminal angle is there. I can keep the interim open. Let them appear.
My lord, then my lord, one thing, my lord, the
Yes.
Next deputy yes. No, November next. Then my lord, because my lord, the next date has been given on November. So my lord, before that.
Yes, yes, of course. Heard Mr. P. Mahanta, learned counsel for the petitioner. Stop. Also heard Mr. R.J. Barwal, learned additional APP for the state respondent. By way of this application under section 482 of CRPC 1973, the petitioner is seeking quashing of the FIR and Izahar dated 29/10/2021, as well as charge sheet being number 421 of 2022 dated 15/11/2022, submitted by the IO in the court of CJM Kamrup Metro in connection with Dispur Police Station case number 3935 of 2021, later on registered as GR case number 17402/2021, and now registered as PRC case number 2108 of 2023 under section 294506 of IPC. Issue notice, returnable 4 weeks. Mr. Bora accepts notice for 1 registered post AD 2 steps within 3 days from today, extra copy suit 3 days. Issue notice on the interim as well. List after 4 weeks on a date to when do you want? Give a date.
My lord, because I can start the Dusty also.
Give a date.
So date may be my lord in October, my lord in 30, my lord.
Returnable on 30/10/2024. Good, yeah.
Master,
list accordingly.
Master.
Mr. Holloway is here. Yes.
Please,
Yes.
We
I'm
were
sorry,
on-
Lordship, I was on days. No, that's all right.
We were looking at the FIR itself and the
Yes.
content of the FIR.
Page.
Page 145. Now, it starts with 142. And before I read, I'll just make one point. 12th June 2022 and 2 o'clock, the FIR registered at Delhi, entrusted to a particular person, Mr. Moray. Now, let's read the content of the FIR and travel further what happens thereafter.
Page.
Page 145. 145 start.
145.
Yeah. That's the content of the FIR.
Lordship, before my learned can start with this argument, Lordship, similar nature case is pending before this honorable court. We have taken time to file reply on those petition, Lordship. Here, the accused person is the company, Lordship, if I'm not wrong.
In respect of the same FIR.
Same FIR.
In what has happened in those matters?
It's pending.
Any stay orders?
No stay order.
May I answer?
No stay order. In one of the accused, the FIR, I mean to say the proceeding has been quashed in favor of one accused.
Proceedings already been quashed. Are you on a similar footing?
No, I'm not. That was my principal reason is, with all respect to my friend, today we are on the issue of whether the order of surveillance, as has been projected by the prosecution, stand the test of the law or not. That's the one issue. 2, if we forget about anything else, does the FIR show that it has been registered and the operation has continued in a manner which...
When is the other case fixed?
It's been fixed after vacation,
where you had
Date,
filed
we
your
will know the date.
return?
We'll give you the date.
We have filed.
Huh?
We have filed our reply in that.
When is that fixed? Date?
Date, Lordship.
But they, in that matter, I've been informed they had not asked for interim. What has happened is
They have asked for interim. They
didn't ask for it. That was my
But
instruction.
you see, the special PP is there. This court gives weight to the contentions submitted by the PPs and APPs. Then I'm posting this matter along with that.
Can I make a small request?
Yes.
Let me issue notice on the matter.
I'll issue notice.
And an interim also.
No interim, because
But
in the
there is a
other
reason.
one there is no
Well,
interim.
well, there is a reason. But can I get justified for 5 minutes only?
Sorry.
Or maybe 3 minutes.
It is already, if there was no, if this court had not gone into the same, has not looked into the same FIR, then it would have been a different thing. The court had a chance and had no interim was given in that case. So I'll fix it along with, I'll issue notice so that if they want to file something, you can file it.
Written objection we are going to
Yes.
file.
You are Mr.
Harsh Sharma.
Heard Mr.
H.K. Sharma.
H.K. Sharma, learned counsel for the petitioner. Stop. Also heard Mr. M. Halway, learned special PP for the
CBI.
For the CBI. Stop. By way of this application under section 528 of BNSS 2024, read with section 482 of CRPC 1973, the petitioner is seeking quashing of the FIR dated 12/6/2022 and the charge sheet dated 10/8/2022, qua the petitioner company filed in the case, along with other consequential proceedings pending before the learned special judge CBI Additional Court Number 2 Assam at Guwahati. Stop. Issue notice, returnable. When is the other case?
6/11.
Returnable 6/11/24. 2024. Extra copies within a period of 3 days from today. List accordingly.
Well, if the interim plea is rejected, that would be the. Because in case Lordship is.
You want me to issue notice on the interim?
Please,
yes,
Lordship.
issue notice on the interim prayer.
I'm so honored. Thank you so much.
Yes, what
Yeah,
is
please.
this
It's
criminal
a regular appeal, my lord, against conviction. Here, my lord, trial was conducted, my lord, under section, my lord, 354 and section 8 of the POCSO.
Yes,
And
Mr. Das,
conviction,
I'll admit it.
conviction at 354.
Heard Mr.
Ayuddin.
Huh?
Ayuddin.
A.I. Uddin, learned counsel for the appellant. Stop. Also heard Mr. B. Das, learned APP for the state respondent. By preferring this appeal under section 374 within bracket 2 of the CRPC 1973, the appellant is assailing the judgment and order dated 3/9/2024 passed by the Learned Court of Special Judge POCSO Nagaon, so passed in special POCSO case number 19 within bracket N of 2022 corresponding to GR case number 4465 of 2021 arising out of Roha Police Station case number 281 of 2021 registered under section 376 IPC, read with section 6 of the POCSO Act 2012, whereby the appellant was held guilty under section 354 of the IPC and thereby convicted and sentenced to undergo rigorous imprisonment for a period of 2 years and also to pay fine of rupees 20,000 and in default of payment of fine further simple imprisonment for period of 6 months. Issue notice, returnable 4 weeks. Mr. Das, so and so accepts notice on behalf of respondent number 1, extra copies 3 days, registered post AD in respect of R2, steps within 3 days. Records has to be called.
Yes.
Let the records be called from the court of Special Judge POCSO Nagaon.
Yes.
From so and so. List after 4 weeks on a date to be fixed by the registry.
I am
What is
for
this?
suspension.
Where is
on
the I?
Yes.
I is there.
Yes. I am on PB, allowed on PB as well till 310. Order is there. So I may be allowed to remain on PB as well.
You are also convicted under section 4.
No, only 354 IPC.
Though there was an offense, but ultimately conviction is only under 354.
352.
So POCSO,
POCSO
there is no conviction. Yes, I cannot suspend it merely because of the asking. Yes.
Because 3 years, less than 3 years, only 2 years is conviction. 389(2), already it is mentioned in the order of the learned trial court. I have given you.
What is this?
Last paragraph.
You are allowed to remain on previous
Yes.
bail. Yes, what do you say?
Yes, normally bail is granted because there is no likelihood of disposing of the appeal.
All right. Heard so and so. This is an application under section 389 of CRPC 1973 for suspension of the execution of sentence and release of the appellant I. Shri Sunmoni Bora, who is released Sunmoni Bora on previous bail in connection with the Agot Jasa judgment in order. Mr. So-and-so submits that the trial court judgment suffers from misconstruction, suffers from erroneous presumptions and surmises, and as such it is manifestly erroneous. Stop. He further submits that the sentence awarded being of 2 years, comma, the petitioner, the applicant be allowed to remain on previous bail pending disposal of the instant accompanying appeal. Stop. Mr. Das, APP, submits that he has received no instructions to oppose the prayer made in the interlocutory application. Stop. Heard, perused, it appears that in support of the prayer made in the interlocutory application, the applicant has averred as under paragraph 2, 3, 4, and 5, and 6. Peruse the aforesaid paragraphs, and as such, a case has been made out for suspension of the conviction and release of the petitioner, allowing the applicant to remain on bail. Stop. Accordingly, the impugned conviction, the operation of the impugned conviction and sentence shall remain stayed, and the applicant shall be released on bail, shall be allowed to remain on previous bail pending disposal of the appeal. Disposed of.
Obliged.
May I please, Your Lordship?
Yes, Mr. Chaudhary.
Hello, it's a 483 application, my lord, regular bail, my lord. Page 10 is the FIR.
Yes, diary has come, Mr. Bora.
My lord.
Bora.
My lord.
Yes.
Page 10 is the FIR, my lord.
What is the offense?
Offense, my lord, murder, my lord. They have alleged murder, my lord. But our case, my lord, possibly.
I think this case perhaps has to. Can this court take this up? Because I find in a similar FIR, Justice Ekya has disposed of.
This case? My lord,
Case checking.
Or because of that order.
There is a notification,
Yes,
right?
yes, my lord.
No, just have a look at it.
No,
because
it's okay, fine.
No, just fine. Mr. Bora, please see.
My lord.
In that index, one is disposed.
Yes, yes, yes.
Dispose that as now. Unwarranted.
Yeah, no.
Our position is 10/9/23.
Correct.
Yes, my lord. The name is same, my lord.
And it says disposed. That's the tracking, FIR tracking. List before appropriate bench. Next.
Lordship, let the matter be taken after some time. Mr.
CD is there? 31.
Yes, my lord. Case that is my lord.
31, my lord.
31. 31. One number.
31 I can.
After some time, will go.
Acha, 33, yes.
Into court or high. 40.
33.
But it is nice. Interim
Yes.
before
Has he
IO.
surrendered?
33. 33 my case that is not the same.
All right. Await case diary. Interim order pass earlier shall continue to the next date of listing. List again on
In the month of my lord,
such and such date.
4th of 11, my lord. 4th 11. Interim.
Already given. Why are you don't stay alert? Cattle. Are you on interim?
Yeah, I am in interim.
Yes.
I have appeared before the IO and
He's
have
appeared?
recorded, yes, appeared and recorded the
Anything?
statement.
My lord.
What about his antecedents?
My lord, there are two accused persons, my lord. First one, my lord, item number 34, my lord. This is 34 Moni Madhav Das, my lord.
I have 34, yes.
Yes, 34 Moni Madhav Das, my lord. And other case, Rishiraj Soikia, my lord.
Has he appeared?
He has not appeared, my lord.
34 has not appeared?
No, my
No,
lord.
I have appeared. I have appeared before the IO
He
and have
says he has
recorded.
appeared.
But
You
his
get-
statement, no, his statement is not in the case diary, my lord.
No, but then you get the updated status.
Yes, my lord.
In item 34, you say let the up-to-date status be called for. Status of case diary be called for. List again on
After
such and
vacation, my
such
lord.
date. Interim passed earlier shall
30,
continue
10, my
till the
lord.
next date of listing.
30, 10.
Okay. 30, 10.
May I please also?
In 35,
There is no interim, Your Honor. I was not allowed interim.
35, but it is similar.
Similar, Your Honor. So I may be
Arising
allowed-
out of the same FIR, my lord. And he is the FIR name accused person. And the injury report is, my lord, grievous, my lord.
Where is the FIR?
Yes, page number 13, Your Honor.
1-3.
One, type copy, Your Honor. May I read?
Yes, please.
With due respect, I beg to inform you that yesterday night, 10/8/2024, at about 9:30 p.m., when my younger brother, namely Ratin Ale, along with his two friends, were coming from Gomiripal village towards home after taking part in a funeral, the below mentioned accused person had stopped them at Jamuguri Weekly Market.
Injury report is there.
Yes, my lord.
Grave.
Grievous, my lord.
Grievous. Iron rods.
No, my lord, it is for the blunt object, my lord.
So wooden log.
Yes, my lord.
Probably the wooden log.
Yes, and injured person also has also implicated this person, my lord.
But what about the antecedent?
Antecedent actually, as per the version of my petitioner, Your Honor,
Antecedent,
There
Mr.
are-
Borwa will say, not you.
There are some altercation took place, my lord. And my lord, this accused person, my lord, they were waiting there, my lord. When the, my lord, informant along with his friend, my lord, they were coming from him, my lord. After cremation of him, my lord, they are near one, my lord. They have attacked them and assaulted.
So there was an altercation.
Altercation.
Perhaps because doesn't make sense. This court is not convicting him, isn't it?
My lord. There are allegations against him, my lord. Because the victim
Correct,
has,
but otherwise there is no adverse antecedent available on the materials, right?
now, my lord, because investigation is going on.
Correct, correct. And what is the stage of investigation?
My lord, it is, my lord, the police is searching the accused person, my lord, because One person, my lord, he has got interim protection of this by this honorable court, but my lord, he has not appeared, my lord, when the case
Okay.
diary came.
I will cooperate you, Lordship.
Heard Mr.
P.
P. New, learned counsel for the petitioner. Stop. Also heard Mr. R.J. Barwa, learned APP for the state respondent. This is an application under section 482 of BNSS 2023 seeking pre-arrest bail to the petitioner, i.e. Shri Risiraj Saikya, who is apprehending arrest in connection with Jamguri Police Station case number 109 of 2024, dated 11/8/2024, registered under section 1262, 1172, 10935 of Bharatiya Nya of BNS 2023. Stop. The case of the prosecution is that on 11/8/2024, one Shri Bisan Ali lodged an izahar with the Jamuguri police station stating inter alia that on 10/8/2024 at about 9:30 p.m. when his younger brother, namely Ratin Ale, along with his two friends, were coming from Gamiripal village towards home after taking part in a funeral, the accused persons, the accused petitioner along with other co-accused had stopped them at Jamuguri weekly market beside the Majgaon petrol pump and tried to snatch their mobile phone and money, and upon resisting, the accused petitioner along with the co-accused beat them with wooden lock, iron rod, etc., for which they suffered serious injuries on head and is under treatment. Accordingly, an FIR was registered. Stop. Mr. So-and-so, learned counsel for the petitioner, submits that the allegations in the FIR is not true and that he has not done and that he has been falsely implicated in the offense alleged. Stop. Per contra, Mr. R.J. Barwa, learned APP, submits that the materials available in the case diary indicates that there was an altercation between the accused petitioner and the informant, for which the fight had taken place, in which the accused petitioner along with the other petitioners have beaten the informant and two others with blunt object, as can be seen, which is also He further, by relying upon the medical report, submits that the medical report further corroborates the version of the FIR that the injury sustained by the informant and the two others, which are grave in nature, has been sustained by blunt
weapon, madam. Blunt weapon or object,
by a
madam.
blunt weapon. Stop. I have considered the arguments made by the learned counsels for both parties and have perused the materials available on record, including the case diary. Stop. It appears that the investigation is substantially is going on, and the statements of the witnesses
Along with
have
the
been,
victim, madam.
along with the victim, have been recorded under section 161 of CRPC.
No, madam, it will be
The new section.
it will be in a BNSS, madam.
Under section
183 or something.
under section so and so of so and so act, CRPC will Stop. It further appears that due to altercation, the alleged incident had occurred in which the informant and 2 others has suffered grievous injuries. Stop. It further appears
180 BNS.
180. It further appears that there are no adverse antecedent available against the petitioner in the materials collected by the investigating officer at this stage. Stop. Considering the aforesaid, this court is of the opinion that custodial interrogation of the petitioner may not be necessary for the ongoing investigation. Stop. Accordingly, the petitioner is allowed the anticipatory.
Let him directly to appear.
I will. Before the arresting authority, subject conditions the demand that number 1 not within 10 days before the he'll appear before the arresting authority.
Yes, my lord.
Arresting authority. Failing which to demand, and I think new conditions have been also given, right?
Yes.
Yes. AER 1, 2, 3, 4.
Only interim, my lord, because the other cases also, my lord, he is on interim, my lord, and let both the cases may come, my lord, on 30 of October, my lord.
No, why interim?
No, because the other, my lord, the investigation going on, my lord, he has not appeared.
I'm disposing this. As far as he is concerned,
no, because but the injured person
he'll cooperate. He has submitted. There submission of denial that he has the petitioner so and so submits that the petitioner shall cooperate with the ongoing investigation. Okay? And if he doesn't cooperate, you can always cancel it. Subject the conditions are given. Disposed of a condition we have 1 to 4, section 482. Yes.
Oblige.
I pray this matter may come up next week any day.
All right. As prayed for by Mr. S.M. Abdullah P. Learned Counsel for the petitioner, list this matter.
Monday, Tuesday, any day.
Give a date.
Hello, we have received the case diary, my lord.
Yes. When?
Monday, my lord.
On Monday.
Oblige.
Case diary received be retained.
Oblige.
Are you on interim?
No, my lord.
Okay. Yes. Why is this matter for orders? Fresh step. Have you taken?
Taken, my lord. We have taken, my lord, 3-9. 3-9, my lord. On 3-9.
Sole respondent. It appears that thereafter also there is an office note which says an unserved notice has been received with postal envelope. No such person. What is to be done? You obtain instruction. As prayed for by Mr.
HP Neog, my lord.
HP Neog, Learned Counsel for the petitioner, list this matter after 2 weeks on a date to be fixed by the registry to enable the petitioner to obtain instruction as regards service upon the sole respondent in view of the office note dated 24/9/2024 to the effect that the unserved notice has been received with postal envelope marked as, within quotes, no such person, RTS.
Let's call for CD, my lord. Let's call for CD.
Yes.
The allegation is that the person who was driving the vehicle met with an accident, and ultimately, my lord, the victim expired. Victim has expired.
Victim expired.
And he is behind bar for last 28 days.
28 days.
28 days.
Where is the FIR?
Lord, you'll find the FIR on page number 10, madam.
Anything, Mr. Borwa?
My lord, there are material, my lord, but the postmortem report is not received, my lord. Because he was in intoxicated condition, my lord, and he was driving the vehicle in a very high speed, my lord.
Harsh manner.
And he knocked down the, my lord, victim, my lord, and he died in the spot. So postmortem report will be required, my lord.
You, what do you have there to show that he was in an intoxicated state?
Yes, my lord, there is a, my lord, report, my lord,
There is a report.
Yes, my lord. My lord, 100 ml alcohol found in, while my lord, doing the bet analysis.
All right, let's wait for the postmortem report. Because, and otherwise 28 days are...
28 days.
You see, because of the intoxication report, this court is not inclined. So maybe you can try your luck on another day. Mr. R.J. Boral, learned APP for the state respondent, submits that the postmortem report is not available in the case diary made available to him. He accordingly seeks accommodation to place the same before this court. Prayer allowed. List. Yes. After 2 weeks or a date?
No,
list
we'll
on
fix
such
them
and
around
such date.
4th of August, madam. 4th of October, madam.
So you call, you have it, the postmortem
Madam,
report. Yes. Why are these matters for orders?
My lord, as per last occasions, first order, lord, regarding service report of respondent number 2, my lord. My lord, as per order dated 7/8/2024, Learned 50 is supposed to convey before the court whether the notice has been served.
Lordship,
from
we have taken our steps in respect of notice, service of notice upon respondent number 2, his
Informant,
Lordship.
Yes.
So that report is awaited, Lordship.
MS?
MS S.H. Bora.
MS?
S.H. Bora.
S.H. Bora.
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 Yes,
You are
Lordship.
APP?
Yes, Lordship.
Learned APP submits that the report as regards service of notice on the respondent number 2 is awaiting.
Yes, Lordship.
List after 2 weeks
Lordship.
on a date to be fixed by the registry.
Lordship,
Yes.
I am representing on behalf of Ms. D. Saitya. She is the amicus curiae of item number 39 and she has received the paper book. Ms. D. Saitya.
You want paper book?
No, she has received the paper book.
38 and 39 was together.
Yes. I was directed and by her to inform the court.
All right.
Of that.
Yes.
Lordship,
Yes.
my senior is out of station. Kindly adjourn the matter for a day.
Why is the matter for orders, ma'am?
Lordship, we have filed our application for grant of special leave to...
Why is the matter today for orders?
Lordship, we have filed application, Lordship, for grant of special leave to appeal, Lordship, against the judgment.
This is a leave application.
Leave application. I also filed affidavit in opposition in leave application, but it was not in the record, Lord.
All right, then we'll call that. You are Mr.
U.S. Borgohain.
Mr. U.S. Borgohain, Learned Counsel for?
Sole respondent.
Learned Counsel for the respondent submits that an interlocutory application for granting leave granting leave
filed by NCB. I filed
objection.
Affidavit in opposition.
Has filed objection in the matter. However, the same is not on record. Let registry verify and place the same on record. List
on next Friday, Lord.
No, next Friday is a motion. List after 1 week on a date to be fixed by the registry.
Have your blessing.
41.
Your Lordship, the LCR has been received. The LCR has been received.
LCR has been received. Service is completed.
Yes.
R2.
I am 2, my lord.
You have R2. LCR paisa. And paper book.
Let the matter be fixed for hearing, Lordship.
Paper book is not
Paper book
required
is,
to be.
perhaps not required, Lordship.
All right. It appears that The case records from the trial court has been received. As parties are all represented, list this matter for hearing in due course.
May I please your lordship? Lordship, notice is yet to be served, lordship.
Sorry?
Notice is yet to be served, lordship.
Await service.
Yes, lordship. On last occasion,
Service on whom?
Lordship of respondent number 2. That is awaited.
Await service in respect of respondent number 2, list after 2 weeks on a date to be fixed by the registry.
Obliged. Lordship, may I please your lordship? Lordship, insufficient addresses found on last occasion, lordship. So kindly press step will be taken by us.
The appellant is allowed to take fresh steps upon the respondent by inserting the correct address.
Through the concerned PS, lordship. Through the OC of the concerned
Through the jurisdiction. This is a POCSO matter.
Yes, POCSO matter.
File code, my lord.
Have you filed an affidavit
Yes,
of
my lord.
service?
My lord. As per office note dated 20 September, it is there, my lord, on the records.
So they're not appearing.
No, my lord. Even on the last 2 days also,
But this is 20th September.
My lord.
So I think we can wait for some time.
My lord, for the last
It has
2
been
days,
only served on 20th September.
my lord, for the last 2 days, they are not appearing in the trial court for cross-examination also, my lord.
Office note dated 29/2024
But it is-
indicates that an additional affidavit on behalf of the petitioners has been filed regarding dusty service of notice upon the sole respondent through her counsel. See, through her counsel.
As per order, my lord. As per last order.
Through her counsel. Stop. A copy of the aforesaid affidavit in service indicates that on 6/8/2024, the notice was served upon the engaged counsel of the respondent.
Sole respondent.
List this matter after 2 weeks. Since there is no representation today when the matter is called, list this matter after 2 weeks on a date to be fixed by the registry.
My lord, the interim, my lord.
Let them come 42. You see, you have served it on the council. This
My
court
lord,
doesn't know whether the council has given it to her or not.
My lord, as per order of this honorable court, my lord.
I have seen. Next.
Obliged.
Yes, Mr. Datta.
Lordship, there is an application under section 378(4) of the CRPC seeking leave of this court.
This is a leave application.
Yes.
Acquittal.
Against acquittal.
First time.
First time. I think notices were issued in the. There
Yes,
is a
any
delay.
objection?
No, madam. Already delay possibly condoned.
Delay is condoned.
Condoned.
Or notices have been issued, I think, in the delay.
No, delay condoned or notice is issued?
Notices issued.
Notices.
Notices.
Which is the delay application? You see, before I take the leave first, this court will have to condone the
The
delay.
delay, yes.
Yes.
Where is the condonation application?
Yes, a condonation application wala IS criminal number 4/20.
4 of 2024.
Yes, 9.
Delay has been possibly condoned.
Delay is condoned.
No,
Mr. Datta. Not expected from you, Mr. Datta. Huh?
Matter may come for admission, but along with the copy.
You are not objecting to the leave. Are you objecting?
Yes, objecting.
You are objecting.
Yeah. Now I am objecting. Then, my lord, after receiving the
Are
copy.
you objecting to the leave sought for? Have you filed your objection? Do you
Not
want
filed.
to,
Not filed.
Do you want to file objection?
Yes, my lord. I have not received.
Then say that.
Yes, my lord.
Why you people make things so complicated? Heard Mr. S. Datta, Learned Counsel for the applicant. Stop. Also heard Mr. R. Das.
H. Das.
H. Das, Learned Counsel for the
Sole respondent.
sole respondent. Stop. Notice also not issued, isn't it?
No, notice has not.
This by way of this application under section 3784 of CRPC, the applicant is seeking leave to appeal against the judgment dated 27/9/2023 passed by the learned additional Chief Judicial Magistrate Demaji in NI case number 29 of 2018. Stop. Issue notice returnable 2 weeks. Mr. So-and-so Das accepts notice on behalf of respondent, on behalf of the sole respondent. Extra copies within a period of 3 days from today. List after so-and-so on a date to be fixed by the registry.
Obliged.
Who has been served and they have appeared.
Yes, I have appeared for the
37 days delay.
My lordship.
In fact, it will not be 37 because my learned friend challenged the order of the original court. And original court acquitted the present respondent number 2. Then my learned friend challenged before the session judge for acquittal, conviction against the acquittal of the accused. And the learned session judge observed that it is not maintainable because the appeal against acquittal only placed before the Honorable High Court. And after my tool of the judgment, this order was passed, and the learned friend now challenged that order. But in fact, if we count from the original order, it will be more than.
The officer has calculated.
So I will file the objection, ma'am.
File your objection.
Yes, ma'am.
You are appearing for?
File the objection, ma'am.
For whom? Respond to?
Respond to, ma'am.
As prayed for by Mr.
Anuddin, ma'am.
Anuddin, learned counsel for the respondent number 2, lives this matter after 2 weeks to enable the said respondent to file objection in the matter.
Obliged, ma'am.
None appears for the petitioner when appellant when the matter is called. List after 4 weeks on a date to be fixed by the registry. None appears for the. Yes, you're there.
46, Lordship.
46.
46.
Why you are in such a state of confusion?
Lordship, I was just coming from court number 1.
No problem.
In respect of 46, Lordship, the service in respect of respondent number 2 has already been completed. Lordship can see it in supplementary record. There is a notice dated 5/9/2024 given by the CJM Dhubri saying that on 3/9/2024 the process server had.
On 3/9.
Yes.
Today there is no representation.
So no representation.
No, no.
Lordship may appoint one amicus in respect of respondent number 2.
Generally for informant, amicus
Yes,
or
amicus.
legal aid counsel?
Legal aid counsel.
Legal aid
Amicus.
counsel.
Amicus also.
Amicus,
Amicus
yes,
can also-
amicus. Normally they appoint amicus.
Mr. Fukan, you are in. You are right. Amicus or legal aid? Amicus.
Into POCSO also.
POCSO.
Single, private or single? It will say.
POCSO for what?
45.
Office note dated 9/9/24 indicates that the service report that service in respect of notice issued to the respondent number 2 informant,
Yes,
stroke informant, has been duly served. Stop. However, today when the matter was called, there is no representation on behalf of respondent number 2. Accordingly, this court appoints Shri Arnav Fukan as an amicus curiae to represent respondent number 2 in the matter. Registry to, is the paper book everything ready here?
Paper book is not required.
Paper,
Paper
single
book
bench
not required.
matter.
Single bench
LCR,
matter.
is it?
Yes,
LCR.
LCR.
Let the appeal memo along with the relevant papers be served to the learned amicus curiae. List this matter for hearing.
Lordship.
When?
Lordship after vacation.
In the month of November?
November,
Yes.
Lordship in the month of anything.
List this matter for hearing in the month of November on a date to be fixed by the registry.
Authorized.
Authorized, Lordship.
Yes, 47.
47 appellant is absent. Lordship.
I'm waiting so that I don't have to cancel the order.
Lordship after some time being.
None appears when the matter is called. List after 4 weeks on a date to be fixed by the registry. Yes, Mr. Das, NDPS.
Yes, my lord.
You have a interlocutory application
lord.
for what? For suspension?
Yes.
Suspension of sentence.
Only where at this stage is that, my lord, the applicant number 1 is suffering from TB. So medical report be called for from the superintendent of jail, Dhubri, my lord.
All right.
Lordship.
Let the medical report, yes, in respect of
Applicant number
the
1.
applicant number 1,
Golzaruddin Ahmed.
within bracket,
Golzaruddin Ahmed.
be called from
Superintendent of jail, Dhubri.
Superintendent of Jail, Dhubri. List after 2 weeks on a date to be fixed by the registry.
Lordship.
Highly obliged.
Lordship, is it through registry or you have to take steps?
No, but this has to be, I think, it is from the jail authorities. I
Yes.
think you are from the office
Lordship.
of, you can
We will
always
take
have it,
Lordship.
isn't
Yes,
it?
we'll take. Authorized.
I have not mentioned it, but generally the manner you get the CD,
Lordship, we'll do
same
Lordship.
thing. If it was court, I would have asked the registry.
Yes, Lordship. We'll take the initiative.
None appears for the applicant when the matter is called. List after 4 weeks on a date to be fixed by the registry. $264 delay.
My lord, in filing the criminal petition, my lord.
This is the first time.
First time, my lord.
Then there is informant notice has to go.
Yes, Lordship.
My lord, I am into prayer, my lord, interim prayer, my lord. The notice has the execute the.
Your delay has not been condoned and you want interim prayer. Heard, Mr.
Jai Hussain.
Jai Hussain, learned counsel for the applicant. Stop. Also heard MS.
SH Bora.
SH Bora. SH Bora, learned APP for the state respondent. By way of this application, applicant is seeking condonation of 264 days delay in filing the accompanying criminal revision petition. Stop. Issue notice, returnable 2 weeks. MS so-and-so accepts notice for 1. Extra copies within 3 days. Register post AD in respect of 2. Steps within 3 days. List after so-and-so. No. Yes, Mr. Odin.
Yes, my lord.
NDPS.
Yes, my lord. The second time, earlier, this your lordship rejected
You have
the
the
bail.
scanned copies?
Keep on writing.
Item 43.
Lordship scan copy was perhaps not called for.
No, it was there.
No, no,
Await.
it was called for. and
Await
also
for
mentioned.
scanned copies last order.
Yes, but in the cost list, Lordship item number 43 scan copy is not mentioned.
No, item 43 indicates with scan copy. I simply. It has come.
Yes, yes.
Have you gone through?
No, Lordship, also kindly give us some time.
Then you have a look.
Yes.
Let her have a look.
Lordship.
There is a part heard hearing. I will take that, and after that I will take it.
Lordship.
Till then you have a look.
Lordship.
Are you asking?
43 petition of the name.
No, I think This is the same.
My lord, this is where this is the.
No, correct. But I was in the middle of the other one where Mr. Chaudhary had appeared. There, Mr. Gogoi, you had not completed. You are correct. So let me complete that. That is, I think, 3769.
Yes, boss.
I am appearing for LGB.
Sorry?
The copy of Finance Board, Standing Council of.
Yes. You want something?
Yes, my lord. He has not provided me any declaration copy.
Copy is not provided?
No, what happens is this, my lord.
Mr. Majumdar?
No, we
In which one are you appearing? In
In my
item number
mathematics.
60, 61, 62? Which one?
60 he wants.
For LGB,
In item number?
60, 61, 62.
In 3. And in 3, petition copy has not been served.
In 60, my lord, not copy.
Only in 60.
Only in 60.
Alright,
What-
you serve it.
I'll give him a copy, my lord. What happened is the registry did not have him as a
Anyway,
standing counsel.
we are
I'll
not
give it to him.
taking 60 right now, so
I'll
you
give it
give
a
it
copy
to
now,
him. Let
right
me
now.
first finish the one which I have started. Otherwise, it is very confusing. It will unnecessarily complicate the issue. Let me finish one. And in fact, Mr. Majumdar, whatever decision is taken in item 62, perhaps
We'll affect
we will thereafter affect you, isn't it?
that on one part of it. The other part, many part will be.
Yes, that's why it is difficult to club it together and perhaps dispose by way of a common judgment. Let me take one by one. 62 to 15 years, you know. And in the meantime, Mr. Majumdar, please ask your junior. Mr. Majumdar, ask your junior to give a copy right away. Yes, Mr. Gogoi.
Actually, yesterday's I have started in my affidavit also. Yesterday's I have.
But I think it would be advisable if all parties give a small note along with the document that you are relying, because otherwise it's a voluminous. In the morning I was going through, but
absolutely not. The facts
you-
are really long.
Mr. Chaudhary, look at the flags.
No, I know. The facts is really longish. At least to appreciate the case, 3-4 pages only will have to devote on facts.
Correct. So whatever is
Yes,
in
yes.
your support, you give me that. Whatever is in their support, because appears everything is ultimately the judgment will have to be delivered after appreciating all these documents,
Exactly.
isn't it?
Correct.
So-
Absolutely.
Yes.
So, Lordship, from page 166 onwards, Lordship, today I am starting, Lordship.
Page.
Page 166, Lordship.
Yes, Mr. Gogoi.
Lordship. Roman 7, Lordship.
Page.
Page 166, internal page, in our affidavit, Lordship.
You have served that notification which you had handed over to me yesterday,
Lordship.
25th January 2005. You have made available a copy to the other side?
Lordship.
You have, right? Mr. Chaudhary, you have got that copy or not? They had they had submitted one office memorandum dated 25th January 2005 to show that the age of superannuation is 58 to 59. Have you have it?
Yes.
All right. Yes, Mr. Gogoi, page.
The Department of Expenditure, like Government of Assam, totally.
It's of Government of Assam.
No, it was given to the court when you were not inside. So
But
I was not
I
sure
got
if you have received
No, I
it.
got it.
Let the Department of Expenditure letter dated 29/2016 stated that
Page, Mr. Gogoi.
page 166, Lordship.
160.
Roman 66 is the affidavit filed by the Union, Lordship.
Roman 7, 8,
Roman
that
7.
page.
Lordship.
You are relying on?
Roman 7, Lordship.
Yes.
And Another paragraph, Lordship, the history of the that institute. That
Now I remember.
I'm
I
not
think you
retyping.
stopped it here.
Lordship. That in consonance with the clause 6 of the agreement between Government of Assam and Northeastern Council, Secretariat, Ministry of Home Affairs, Government of India, the terms and conditions of the employees, that is the employees of the state government, has on the date of agreement of 11/2/1999.
One sec. It is, why is this page a little different?
166.
There are two 166 in my brief. In 166, the Roman 7 and Roman 8 paragraph appears. In the other 166, it is only paragraph 8. Now, which one?
But the one with 7 and 8.
7 and 8.
Roman 7.
তুমি তো গভর্নমেন্ট অফ ইন্ডিয়া এফিডেভিটখন পঢ়িছা
হয় Government of India.
হয় দিয়া 7 and
Yes, read.
7 and 8, Lordship,
Read.
166.
You're reading that Department of Expenditure.
Lordship. That the Department of Expenditure of letter dated 29/2016 stated that in consonance with the clause 6 of the agreement between the Government of Assam and the Northeastern Council of Secretariat, Ministry of Home Affairs, Government of India, the terms and conditions of the employees in the, that is the employees of the state government as on date of agreement 11/2/1999 shall not be altered to their disadvantageous position. Lordship. As these employees are stated to be governed by the Assam Service Pension Rules 1969, it would be appropriate if pensions of these employees as per these conditions are continued to be paid rather than applying the CCS Pension Rules 1972. The same was conveyed by the Ministry of Health and Family Welfare to the LGBI RM White letter dated so and so, Lordship. And I will place the letter also, Lordship. Next, Lordship, clause 8. That the clause 20 Roman 8, clause 25 of the Constitution of LGBI Tezpur are set out below for ready reference, Lordship. 25, tenure of service. The superannuation age of the faculty staff is 65 years. For non-teaching staff, specialist doctor is 62 years, and for the other staff is 60 years. There are 3 categories as per the Constitution of the LGBIM, Lordship. One is faculty staff for 65 years.
They had shown one notification to say it is not applicable in the case of the petitioner because he is inherited. That word was inherited. Inherited.
Lordship. That part I will, Lordship, reply as per our High Court judgment. What should be there, Lordship?
What should be there?
What should be there? Whether they are inherited or not, and which rule is governed in their service, as per our High Court judgment, I will place it, Lordship.
That the one which was
that yesterday
relied
by the Lordship learned AG, Lordship.
That was
Ravinder Chandra Dev, Lordship.
All right.
Lordship. Only 2 small paragraphs I will rely, Lordship.
All right.
That the petitioner had accepted the offer of the respondent and therefore will be covered under the Constitution and bylaws of the institute. The Government of Assam notification raising the retirement age of the faculty will not be applicable on the petitioner, as neither the petitioner is an employee of the Government of Assam and neither has any lien on the service in the Government of Assam. Next page, Lordship. After accepting the offer of the respondent, Lordship. Further, it is submitted that no action has been done by the respondent against the petitioner by which he can claim that the service of the petitioner has been altered or the petitioner has been put to a disadvantageous or the action of the respondents creates any hardship on the petitioner, Lordship. Then, Lordship, Roman 9, Lordship, that the notification dated 14/2/2022 issued by the National Medical Commission is only a direction with respect to the maximum age limit to which a person can be appointed or granted extension or re-employment. Kindly mark it. In the present case, the petitioner will be covered by the Constitution and bylaws of the institute, whereby the petitioner has to superannuate from service at the age of 65 years, Lordship. And 10, Lordship.
According to you, you are saying that they are covered by the Constitution.
Constitution, Lordship. And the MCI guidelines, Lordship, I will explain.
Then, you see, is it contrary to the argument that was made by Mr. Saikia?
No, Lordship.
No, Mr. Saikia says it is applicable to that 8th category.
Lordship, it is as per the argument advanced by the learned AG, Lordship.
Mr. Saikya's argument was very
No,
specific.
so Kia's argument says that if he is a joint director, then also he has to retirement up age of 60.
No, you cannot be making
No,
dual arguments.
No,
You
no.
have to be. You see, in fact, Mr. Gogoi, Mr. Chaudhary also. I'm just saying.
No,
it.
Lord, sir.
When I was going through the pleadings also,
Yes.
it is not very clearly saying anything. Neither this side says it nor you people say it. There has to be a very
No,
clear.
our stand is very.
Because now you are showing from this. In fact,
Yes.
yesterday also you were showing the constitution and you are saying that it has to be as per the constitution. But Mr. Saikya was saying that it will be as per that category A.
Category the learned as his submission is on the basis of that he is claiming the superannuation or as per the OM issued by the government of Assam, which is extended to up to the age of 70 years. In that particular point, the learned as he has said that submission is this, Lordship, that this OM is not applicable in the petitioner's case as because he is the category A of the Assam service when he was initially in the government of Assam, Lordship. The submission before the learned as is on that particular point.
Alright.
As because he is claiming the OM issued by the government of Assam where enhanced the age of superannuation of the doctor is 70 years. That's why learned as he has submitted before your Lordship that he belongs
That
to the
comparison cannot be drawn
Lordship.
because that 70 is only for a faculty
Lordship,
member
Lordship.
and
He is the
65 is for the
Lordship, he is the
non-faculty
non-fac-
member in the case of that category.
law category. And immediately the submission of the petitioners also that he belongs to that particular category. That's why learned as he has
All right.
advanced this argument. Now, Lordship, Roman 10. The Ministry of Law and Justice, Department of Legal Affairs has opined that Government of Assam notification dated so enhancing the pensionable age of 70 years is not applicable to the petitioners as the petitioner being an employee of an autonomous body of the central government, that is Lukopia Gopinath Bolle Regional Institute of Mental Health, Tezpur, Lordship. Then, Lordship, paragraph 4. That the deponent begs to state that the statement of the petitioner claiming that Government of Assam will be unable to bear the financial burden of the GPF benefit is wrong, incorrect and denied, Lordship. It is wrong, incorrect and denied that the respondent have done any action which is disadvantageous to the petitioner. It is submitted that Department of Expenditure, Government of India had directed the Ministry of Health and Family Welfare that it would be appropriate for the pension of the petitioner to be governed by the Assam Service Pension Rules 1969 in furtherance to the respondents by letter dated so and so, directed the pension cell of the LGB RIM Tezpur be created for disbursing the pensions benefits as per the Assam Service Pension Rules. All benefits etc. would be disbursed by the LGB RIM Tezpur to the petitioners except the GPF as the same is maintained by the Government of Assam in case of inherited employees. The petitioner, after accepting the offer of directors, next page, Lordship, probably page number is missing in this.
No, I have it.
Lordship. The petitioner, after accepting the offer of directors post in 2002 in LGB RIMS, cannot turn around and state that Government of Assam notification would be applicable and the same benefit be extended to the petitioner. Further, the notification issued by the National Medical Commission only states the maximum age which can be considered for faculty, Lordship. Further, the agreement dated 11/2/1999 between the Government of Assam and the NEC in clause 9.5 clearly reads as the rules set out in the constitutions and bylaws of the institute hereto shall constitute the rules for the administration and management of the institute from the date of commencement of this agreement. Such rules may from time to time be altered, added to or modified by the Executive Council with the approval of the Board of Governors, and the rules so altered, added to the modified shall operate from such dates to retrospective date or otherwise shall be notified by the Council with the approval of the Board of Governors, Lordship. Then, Lordship, paragraph 5, that the deponent begs to submit that the petitioner is bound by the constitutions of the LGB RIMS and it is to superannuate from the service at the age of 65 years as because the service condition of the petitioners is governed by the provisions, prescriptions prescribed in the constitutions of the LGB RIMS. As such, it is not a fit case, so and so.
Yes.
This is the stand of the Lordship Union of India regarding, Lordship, the enhancement of age, whether he is applicable or not. As per the stand of the Union of India, the retirement age is 65 years, not beyond that, Lordship. As per the Constitution's, Lordship, it should be 65 years. And the NMC guideline is a, Lordship, as a recommendatory nature, and it is enhanced up to the maximum age limit of 70 years. And the particular NMC guidelines, there is a history behind this NMC guidelines, Lordship. Some of the institute, there is a stance that, Lordship, on extension, Lordship, some persons up to 80 years, more than 80 years, they are continuing. Some of the institutes are director also, and the aims also.
So that is why the maximum.
Even Delhi aims also, Lordship.
So maximum is stipulated.
Maximum is stipulated. Even Delhi aims, Lordship, and Ranchi aims also, Lordship. That was done. That's why after going through the history, that the NMC has framed a specific deadline, Lordship. After that, you cannot, Lordship. And Lordship, regarding that, my Lord may then Lordship may kindly come to read petition, Lordship. Read petition, Lordship. Some of the pages I will rely, Lordship.
Yes.
Page 30, Lordship. It's a part of the agreement, Lordship, and Annexure 3, Lordship.
I somehow
Six.
open page 30 only.
Lordship.
I have 6 in front of me.
Lordship, 6, Lordship, plus 6, Lordship. All the incumbent officers and other employees of the institute shall, as from the date of the commencement of this agreement, be governed by and the subject to the rules set out in the Constitution and bylaws. My Lord may kindly mark it. Set out by, subject to the rules set out in the Constitution and bylaws of the institute hereto, as amendment from time to time, Lordship. When the, Lordship, transaction is going on between NSC and the State of Assam and the LGBI, Lordship, then the clause 6 was inserted that after commencement of the, it should
At
be.
that time, the constitution
No,
has
Lordship,
not come.
no. At that time, agreement was just handing over agreement, Lordship. That point of time, it says that the future actions will be, Lordship, as per the Constitution or bylaws.
Has amended from time to time.
Time to time, Lordship. And all the existing employees will be governed, given the choice of absorption in the new setup or reversion to the government of Assam. The terms and conditions of the governing all employees serving in the employed institute shall not be altered to
No,
the
serving and employed
serving and employed
shall not be altered to the
disadvantageous position.
I think perhaps this means both in case of the earlier and the new that will come in, because at that time no set terms has been fixed, because constitution is yet to come. So once the constitution has come, if it is contrary to any of their terms, that perhaps
that's why that was
is that the correct interpretation?
That is the correct position as per my Lord indicates. That is the correct position. It should not be disadvantageous position. As because they
because
are
at that time the terms has not come.
Lordship. As because they are enjoying some benefit, Lordship. You cannot, Lordship, curtail that benefit, Lordship. We can enhance it, but we cannot curtail it, Lordship.
All right.
And on the basis of that, Lordship, after that also, Lordship, one of the vital document is in our affidavit also, it is not there. In the petitioner's case also is not there. One of the vital document is there in the, Lordship, item number first motion to direction just required. This is one of the most important documents which is required for proper adjudication of the issue, Lordship. So, Lordship may kindly.
In that, also a similarly situated person like the petitioner has filed. Who's the petitioner in that motion matter?
In that petitioner, that particular person was, Lordship, compulsorily retired from service, Lordship. He comes against that, Lordship.
No, but otherwise his case is also like that of the
like
petitioner.
that, Lordship, whether
he was earlier working under the Tejpur Medical Hospital and
Lordship. If Lordship,
and that was what post?
In the post of professors, Lordship.
Professor.
And if Lordship held that, Lordship, the age of superannuation is 65 years, we cannot beyond that age, then Lordship, the actions will come in this case, Lordship. So Lordship may kindly peruse for a moment, Lordship, one of the vital document in page 137, Lordship. In WBC 4975-2024, Lordship.
Yes.
137, Lordship.
Yes.
Lordship, this is one of the most important documents, Lordship. At first, when earlier Lordship from the government of Assam Lordship, it was to the NEC, Northeastern Council Lordship. From NEC Lordship, it was from the Ministry of Health and Family Welfare, Government of India Lordship. It is the one of Health and Family Welfare. This is the most important document. Memorandum of Understanding the transfer of Lukopia Gopinath Bolle Regional Institute of Mental Health Tezpur to the Ministry of Health and Family Welfare. My Lord, may kindly mark it, Lordship.
Yes.
Then Lordship may kindly come to Lordship next. There is some terms and conditions there, Lordship. Now, therefore, it is hereby. If Lordship permit, I can read it the first portion also, Lordship. This MOU is made on 30th day of May 2007 between the Northeastern Council, a statutory body having its office at Shillong, hereinafter called the NEC, Ministry of Development of Northeastern Region, Bigyan Bhavan, Annex in New Delhi, so and so, Ministry of Health and Family Welfare, Nirman Bhavan, New Delhi, Lordship. Whereas the Prime Minister in his meeting held on so and so had decided to transfer the Regional Health Institute of Northeast Policy Academy to concerned line ministries in the Government of India. My Lord, may kindly mark it. Yes, because Lordship, earlier the institute was under the Ministry of Lordship, Northeastern Council, Lordship. So, Lordship, as per the resolutions of the meeting of the Prime Minister's Lordship, it is 16/10/2016, whereby it decides that the three premier regional health institute Lordship, which is under the Lordship statutory bodies, that should be transferred to the parent ministry Lordship, in the line of ministries in the Government of India. Whereas the NSC in its 53rd meeting on 15 and 16 November 2006 also endorsed the decision to transfer three health institute, namely LGB RIMS Tezpur, RIMS Imphal, and RIPANS Aizawl to Ministry of Health and Family Welfare, and NEPA to Ministry of Health and Family Welfare, to these institutes relating to their regional character, Lordship. And whereas the committee constituted under the chairmanship of Dr. So-and-so, the Governor of Manipur, to examine the modalities of transfer of this health institute, recommended that the three regional health institute may be transferred to the Ministry of Health and Family Welfare, and handing over may be completed by end of the financial year 2006 and 7, Lordship. And whereas the recommendation of the Sidhu Committee has been accepted by the Honorable Minister Donor, Lordship. And whereas the pursuant to the MO Minister of Donor, Government of India's Order Nong so and so, Lordship, dated 23/5/2007, the approval of the competent authority has been communicated to transfer of the LGB RIMS to Ministry of Health and Family Welfare, Government of India, Lordship. And whereas the Ministry of Health and Family Welfare will be providing the budgetary support to the institute with effect from 01/06/2007. My Lord, may kindly mark it.
Mark what? The date?
Lordship. From that particular date, Lordship, that particular institute is come under the control and Lordship, control of Ministry of Health and Family Welfare, Government of India, Lordship. This is the vital date, Lordship. It is before that, it is under the NEC, Lordship.
Yes.
Then, Lordship, the terms and conditions are, Lordship, below. The MOU shall come into force with effect from 1/6/2007, Lordship. The Ministry of Health and Family Welfare shall take over the control and management of the institute with all its assets and liabilities, Lordship. The handing over and taking over of the institute shall be with effect from 1/6/2007, Lordship. Then next page, Lordship. The regional character of the institute shall be maintained in the matter of seat distribution and autonomy of the institution, Lordship. To maintain the autonomy of the institution, the existing two-tier management structure should be retained, Lordship. Then, Lordship, the recommendations of the committee constituted under the chairmanship of Dr. S.S. Sidhu, His Excellency the Governor of the Manipur, on transfer of the Regional Health Institute shall be followed by the Ministry of Health and Family Welfare, Lordship. All proposals for then, my Lord, may kindly mark it, one of the important point. This is, Lordship, Roman 7. All proposal for upgradation, modernization, expansion of the institute, as well as those for creation of posts. Lordship may kindly mark it. Etc. shall henceforth be done by the Ministry of Health and Family Welfare with effect from 1/6/2007. With effect from 1/6/2007, there is no power in the hands of Executive Committee or high-powered committee to create any post, to taking any decision in respect of employment. Lordship. It is vested to the Lordship Ministry of Health and Family Welfare. As per the memorandum of understanding, which was Lordship issued between the NEC and the Ministry of Health and Family Welfare, when the institute was directly transferred to the ministry. Lordship.
Because it says MHFW shall take over the control and
Lordship,
management.
Lordship. And Roman 7 says that all the proposal for upgradation, modernizations, expansion of the institute, as well as those for creation of posts, etc., shall henceforth be done by the Ministry of Health and Family Welfare with effect from 1/6/2007. Lordship. So, Lordship, from that particular date, Lordship, 1/6/2007, the all control is vested to the Ministry of Health and Family Welfare. The EC has no power to create a post, Lordship. Regarding service conditions, he has no power, Lordship. All power is vested to the Ministry of Health and any decision taken by the Ministry of Health and Family Welfare is binding to, Lordship, that particular institution. Then, Lordship, Ministry of Health and Family Welfare shall take appropriate action on the recommendation of the expenditures of Finance Committee meeting held on 22/2/2007 regarding constitutions of Technical Committee to revisit, define aspect and rework cost, etc. Lordship. Here I am relying, Lordship, Roman 7 basically, Lordship, where it says that all power is vested to the Ministry of Health and Family Welfare, Lordship, regarding upgradation, modernizations, expansion of the institute, as well as those for creation of posts, etc. etc. Lordship. Then, Lordship, other document which was relied that day, Lordship, that yesterday my senior sir, Lordship, it is page 46, Lordship. 46 of the repetition. That repetition, Lordship. I am troubling, Lordship.
No.
Lordship.
Yes.
Lordship.
46.
46.
Yes. 3rd November.
3rd November 2023. This is a letter issued by Lordship Mr. H. Dotto, Deputy Director, LGB RIMH Tezpur, Lordship. My Lord, may kindly mark it, Lordship. Even that, Lordship, this particular post is, till today, this particular post is not there, Lordship, as per the creation of post, Lordship. There is no post of Deputy Director in that particular institute as per the Government of India's notification, Lordship.
This document was shown for clause 17.
Clause 17. This document was issued by, Lordship, so-called SOD of the Director, Lordship. It is not issued by the Ministry of Health and Family Welfare, Lordship. He cannot decide or he should not decide the service conditions of the employee of the LGBI Institute. He cannot dictate the Ministry of Health and Family Welfare that clause 20, section 20 or article 20 is not applicable in this case, Lordship. He is not the authority, Lordship. Even that particular post is not there till today, Lordship. That Deputy Director post is not there. And even I can show the Lordship that Lordship post creation part also, Lordship. Here they have relied clause 12, paragraph 12, Lordship, and 10 also, Lordship. Paragraph 10.
Non-tenure post.
10. It says that Dr. S.K. Deori was accordingly absorbed into the Government of India and regularized as a non-tenure post to the Director as per the order of the NEC of June 2002, Lordship. There is no order regarding, Lordship, a non-tenure post, Lordship. And there is no order.
According to you, there is nothing.
There is
non-tenure.
Lordship. There is no order regarding absorption, and that was, Lordship. If Lordship kindly come to the page,
These are
Lordship.
not on pleadings, Mila.
It is
These
in
are argument.
It is in pleadings, Lordship. It is in, from their document I will show, Lordship. Their document I will
No,
show.
my lord, they must accept.
Their document I will show.
Imputation, no, my lord. My learned friend is imputing some personal knowledge. My lord, what had happened? There is another case which my friend Mr. Majumdar has moved. So these are all connected, my lord. Now, question is, just now my learned friend has made a submission that this document does not exist. Then you must, so I cannot be taken by surprise. So that I can go through. In your affidavit, you have not said anything. Can we see from 166, 3 to 169 is their affidavit? Where have they said all these things? There are only
Have
cases.
you pleaded anywhere that the post of deputy director does not exist?
Deputy director, we are not pleaded. Otherwise, this post is now from the creation letter. I will show the from the creation letter, which is annexed herewith. I will show lordship. Whose creation letter? I will place it lordship. And regarding absorption part, he categorically says that lordship in paragraph 10 there is absorption. So my lord may kindly come to the page 44 of that particular writ petition lordship. That answer will be there lordship. Page 44. This is petition lordship. Page 44. The answer is there lordship. I am not beyond that documents lordship. I am not submitting a
This is an encadrement,
lordship. So lordship may kindly
not permissible.
lordship. So lordship may kindly peruse it lordship. Page 44.
Yes. Encadrement.
Paragraph 10 of the page 47. The so-called deputy director says that he was absorbed lordship. It says that accordingly absorbed into the government of India lordship. And my lord may kindly come to page 44.
Alright, so you are trying to say that since his encadrement was rejected, therefore it cannot be said that he was absorbed into the government of India.
Lordship first.
This is what you are saying?
Lordship, Roman 1 itself says that I am directed to refer to the subject mentioned above to the state that the matter has been examined by the CSS divisions of the ministry. CSS division has informed that the proposal for encadrement of the Dr. Dewey into Central Health Service cadre is not
Can
agreed.
this matter not be approached by another perception? Because the entire issue is what should be the age of superannuation of the petitioner be, correct? Now here, instead of going through so many documents, I think one or two documents perhaps is most important. Number one, what was the age of superannuation at the time the MOU was entered in 1999? This is very important because that would mean what was the superannuation age at that time and what was the post he was holding, whether it is a category, B category, what post it was, and what was the age of superannuation. Correct. This is number one, which is very important because that would indicate that his terms, as per that at that time that was prevailing, that was the age of superannuation. Now, subsequently, constitution has come. Subsequently, some ages have been enhanced. Now, if one has to take advantage of that, at that point, what was there is most important.
That is the no.
Now, if one approaches in that way, then all these things whether are required.
Why?
Because here that is the only issue.
That is the only issue, and that moot question has to my lord decide. I am pointing out as because there is a lordship heavy emphasis is yesterday that he has permanently absorbed lordship in the CS cadre. But lordship,
No, I don't think that was Mr. Chaudhary's submission because if I recollect, Mr. Chaudhary was very clear that he is neither been encadred the live streaming. He says he's hanging because this encadrement is also rejected one side. Assam government also is saying this was his argument.
He is referring that argument, referring that page that says that you are permanently absorbed.
See, Mr.
So, I am saying that he is not permanently absorbed lordship. So lordship may for a moment lordship may kindly peruse page 44. Page 44 lordship. Page 44. Then I will come to the moot question which was framed by my lord. Page 44.
You all can go on arguing for days to days, no difficulty. But that will only delay the judgment because it will not do any good to anyone. Because if that is the issue, short issue, then I think one should just
I have to clarify
confine to it.
I have to clarify two things. As because his affidavit in reply also says that high power committee has taken decision lordship. That part I have to place it lordship. Otherwise lordship it's the wrong way lordship. So I am saying that lordship Roman 1 CCS rules 2014 does not provide for absorption as a method of recruitment at any level, Lordship. Then, Lordship, the encadrement of the created post only permissible under CSS rules 2014, not for the incumbents holding the created post, Lordship. So, Lordship, from that particular document, it reflects that, Lordship, he was never absorbed in the central government, central health services, Lordship. And one of the documents, they have 2010 documents, they have relied, Lordship. One of the documents they have relied, Lordship. Regarding, Lordship, page 132 of the affidavit in reply of the state, Lordship. This is the recommendation of the committee they have relied, Lordship. So, Lordship, my lord may kindly come to page 133. Who has signed it, Lordship? Page 133, Lordship, extreme right, Lordship. Whether he can become a judge of the own case, Lordship, how his service condition should be, Lordship, should be there or should not be there, Lordship. Then my lord may kindly come to page 158 of that particular, Lordship, document, a particular affidavit in reply, Lordship. 158, Lordship. Just like leaving 2-3 documents, then I will come to the, Lordship. When this, Lordship, permit, I can read it, Lordship. Paragraph 3. When the institute was under the administrative control of the government of Assam, the director of the institute was appointed to a non-tenure regular post, and if the post is now made a tenure post after it was taken over by the government of India, my lord may kindly mark it. If the post is taken over by the government of India, then the incumbent will be without a job after completion of his tenure, Lordship. The incumbent director was absorbed into the government of India, falls as a director of the institute after the takeover, Lordship. That reply is page 44, Lordship. The members noted that the director is a qualified psychiatrist and has more than 10 years of service left. The Honorable Chairman proposed that the incumbent director may be regularized in his service till the date of his superannuation, as it would not be proper to change the rules of a disadvantageous stage, Lordship. My lord may then, page 157, my lord may kindly peruse. 157, the date of meeting, Lordship, 24/2/2011, Lordship. My lord may kindly mark it, the date when meeting was held, 24/2/2011. And at that particular day's meeting, the chairman of that particular meeting proposal was says that he has left more than 10 years service only. That is on 2011 for superannuation 10 years, Lordship. That is their meeting, Lordship. It is not the meeting of the Ministry of Health and Family Welfare. It says that he have to superannuate after 10 years, Lordship. So they have said that in the meantime that post should not be made a tenure post, Lordship. This is their proposal, Lordship. Not acceptance by the Ministry of Health and Family Welfare. As per the 2007 Memorandum of Understanding, 2006, Lordship, all decision has been taken by the Ministry of Health and Family Welfare. That particular committee has no power. Even assuming that that particular committee has a power, Lordship, then it is an admitted fact that 24/2/2011, The petitioner has left only 10 years of service, Lordship. And next page 159, my lord may kindly peruse. Who have signed it, Lordship? Extreme right, Lordship. This is by the petitioner himself, Lordship. This is by the petitioner himself, Lordship. This was a recommendation of the committee, Lordship.
Yes, Mr. Saikia had argued this
Lordship.
yesterday that
Lordship.
he had himself, the executive member, as an executive member, has
Lordship.
done it.
Lordship.
You
Now,
already argued all this.
I just point out 2011 meeting. What is
Because
what
this court remembers the
Lordship?
arguments.
Yes, because he is relying that document. So I am, Lordship, indicating that, Lordship. Indicating that, Lordship, in 2011, they themselves says that he has left only 10 years of service. So in the meantime, that post should not be created as a term post, Lordship. It is admitted case that after 10 years, he will be go
Anything
retired.
changes if it is a tenure or non-tenure?
Lordship.
Does anything change? If
Lordship,
it is a
as per
tenure or
the our High Court judgment, we go by the Constitution.
does it change anything? Does it affect the issue that is involved in this petition?
Not since even superannuation is will take out if
Mr. Gogoi, are you following what this court
yes,
is
yes,
asking?
Lordship says indicate that if we treat it as a tenure post or if we
Or
treat
non-tenure.
it as a non-tenure post, then there will be any change.
Correct. In the
At
issue
this
that
stage,
is involved.
at this stage, there is no
There is
change.
no change. Then
Today it is no change. If it is before 10 years, then there will be a change, Lordship. Now at this stage, as because he has already 65 years, he have to go, Lordship. If it is filed before, Lordship, 10 years, then there should be some issues regarding whether it will be or it will not be, Lordship. Then, Lordship, regarding that part and other documents also there, Lordship.
Mr.
Yes.
Becca, you have a matter?
My lord, make another affidavit in reply, Lordship. Only one page I will show, Lordship. So my lord, make take page 249, Lordship.
Page?
Page 249, Lordship. 249, Lordship.
249.
249, Lordship. 249, Lordship. Lordship, got it?
Yes.
It is a letter of Lordship, 19 June 2012, Lordship.
This was referred by them.
Lordship. Paragraph 2, Lordship,
Inherited.
last two lines, paragraph 2, Lordship.
As regards the
As
inherited.
regards to the inherited employees, a decision is yet to be taken on the status to decide their entitlement for post-retirement benefits and GPF, etc. So, Lordship, may kindly mark it, Lordship. We have said that GPF is as per our affidavit from the state government, other is as per the, Lordship, the Assam pension rules. They have yesterday relied that till today no decision was taken, Lordship. The answer is, Lordship, in the writ petition, page 42.
So according to you, the petitioner is an inherited employee or not?
Lordship, he is from government of Assam. On Lian was permanently
Inherited or not inherited?
inherited, Lordship. He is a permanently
So
absorbed.
there is no
There is no
quarrel
dispute.
to
There
that.
is no dispute, Lordship. As because he is not a direct equity, Lordship. So, Lordship, that answer is, Lordship, in page 42 of the writ petition, Lordship. Yesterday says that till today no decision was taken on the basis of the 2012 letter. But what 2016 letter says, Lordship?
42.
42, Lordship.
Yes. As per Assam.
Lordship. This is the decision of the government, Lordship. That decision was already taken in 2016, Lordship.
And this is of 2012.
In 2012, Lordship. The letter which was relied yesterday, Lordship. 2016.
So you are saying that after this, the decision already came?
Already taken, Lordship. Even clause 6 specifically mentioned that, Lordship. On the basis of that decision was taken, there is no dispute, Lordship.
All right.
Regarding, Lordship, the NMC I have to clarify, NMC part, Lordship. NMC part, my lord, kindly peruse page 61, Lordship. After that, I will go to the, Lordship, the moot question which came by my lord.
Yes.
Page 61, 3.2, Lordship. My Lord may kindly mark it. The maximum age limit. Maximum age limit up to which a person can be appointed or granted extension or re-employed in service against the post. So, my Lord may for a time we pause here. So, Lordship may kindly mark it. Maximum age limit up to which a person can be appointed. It is not a case of appointment, Lordship, or granted extension. It is not a case of extension, Lordship, or re-employed in a service. It is not a case of re-employed.
So this is not applicable.
Lordship, that particular three category, petitioner neither a Lordship case of within the ambit of the appointment,
All right.
within the ambit of the granted extension,
All right,
or
Mr.
re-employed.
Gogoi, I've understood.
Lordship.
You've drawn the point.
Lordship, teachers of medical college, dean or principal, so director as the case may be, which are required to be filled up as per the norms of the National Medical Commission, required to be filled up, Lordship. As per the norms of the National Medical Commission, in any medical college institution for imparting graduate or postgraduate medical shall be 70 years. Maximum age limit is, Lordship, as a maximum
In
cap
the
is
case
70
of
years.
appointment or granting extension or
Brilliant.
re-employment.
Re-employment, maximum is 70 years. Beyond 70 years, we cannot. The fixing of cut-off years 70 years is the history that some persons
You already said, Mr. Gogoi, no point of repeating.
Lordship. So it should be the up to what extent we can.
All right.
Lordship. Then, Lordship, two vital document, another document is there, Lordship.
What is this document?
Lordship,
Have you given it to other side?
I will provide, Lordship. I will provide.
Why documents one after the other are being placed in this fashion?
I will provide the document. I have read it and I provide it, Lordship. It is a, Lordship, the office memorandum of 2022, Lordship.
Yes.
Superannuation, extension in service, and re-employment, premature retirement, and VRS, Lordship.
This is Government of India.
Government of India, Lordship. So, Lordship, my Lord may directly come to Lordship B.
BB1, Central Health Service.
Lordship.
Age of superannuation.
And Lordship may kindly come to B, Lordship, in the third page, Lordship.
In third page.
Third page, Lordship.
Age of retirement.
Age of retirement of the autonomous bodies and organization, Lordship. The LGBI RM is a autonomous bodies, Lordship, under the central government,
58
Lordship.
to 60.
Lordship. And it can be extended up to 62. It cannot be,
But
Lordship.
this is not applicable to the petitioner. He is
So,
not from the Government of India.
After that, Lordship, I am just indicating, after the as per if we go by the ministry's, Lordship, office memorandum, Lordship, we are not placing that office memorandum applicable here. If we go by the ministry's office memorandum, then also it cannot be beyond the 60 years, Lordship. Now, Lordship, have to decide the actual moot question, Lordship, whether the petitioner, what is the maximum age limit of the petitioners, and whether petitioners can be, Lordship, beyond the age of 65 years or not, Lordship. For that purpose, I am relying to paragraph of the, Lordship, the our High Court Division Bench judgment, Lordship.
Yes.
I am relying paragraph 14 and paragraph 27, Lordship. Paragraph 14, only 2 lines I will read, Lordship. I am not troubling, Lordship. It is sorry. Rabindra Dev.
Yes. Paragraph 14.
Paragraph 14, Lordship, last 2 lines I am relying, Lordship. Only last 2 lines.
However,
Lordship.
However,
made it explicitly clear that the state government employees would not be able to serve the institute except in accordance with the rules and bylaws of the institute. I may kindly mark it. Then, Lordship, I am relying paragraph 27, Lordship, the quoted portion, Lordship.
Yes.
Lordship. As provided in clause 6 of the existing employees numbered so and so appointed against the substantive post continued in the institute with rights vested in them to exercise option for consideration of absorption, the provision in clause 6 make it clear that with effect from the commencement of the agreement, the officers and employees of the institute will be governed by the subject to the rules set out in the constitutions and bylaws of the institute. My lord may kindly mark it. And they will be given the choice of that part. I am not relying, but it is the findings of the court is that lordship they will be governed by the subject and rules set out by the constitutions, lordship. Now, what the constitution says, lordship?
60 years.
65 years.
Non-staff.
65 years, lordship.
Hmm?
Constitution. Constitution देखना होगा कल के थोड़ा. Constitution देखिए.
Faculty 65. Non-teaching specialist doctor 62 and for others 60.
Yesterday I have handed over the constitution
I have.
to lordship.
65 is for faculty.
Faculty. And lordship for the appointment of director. As per the division bench judgment, lordship, we go by the constitution, lordship. And
So according to you, he is a faculty.
no, lordship. He is not a faculty. I will reply it, lordship. He is not a faculty. Never a faculty, and he cannot be a faculty. He cannot demand as a faculty, lordship.
And he, what about specialist doctor?
He cannot be a specialist doctor also.
So he is other staff according to you.
He is other staff administrative. He is the director.
60 years.
Director post, lordship. Now, lordship.
That is 60 years.
As per this 60 years, we are not claiming 60 years. Now,
No, but you see, that's
lordship.
why I'm saying everything is very
Lordship.
unclear because
Lordship.
just now you are
No,
saying that this is
no,
you refer to the DB judgment showing that the constitution.
As per the
has to be
constitution,
followed.
lordship,
Correct.
constitution, he should go, lordship, in the 60 years, lordship. As per the, if we go by the constitution, he have to go in when he's completed the 60 years, lordship. He have to go in the 60 years, lordship. If we go by the division bench judgment, lordship. Yes, because at the same time, he cannot be a faculty, lordship, cannot be a professor, lordship. Or director, he cannot be at the same time, lordship. Either he should be a director, or he may be a professor, or he should be a professor. At the same time, he cannot be a director professor. But my learned senior sir's yesterday submission is that he is a director professor, lordship. He cannot be, lordship. He cannot hold two posts at the same time, lordship.
Yes.
Appointment of director, lordship. The director of the institute shall be appointed by the chairman of the council by invitation on the recommendation by a search committee duly constituted for the purpose of the council. Next, lordship, the terms and conditions of the appointment and emolument, etc., will be decided by the council. Director will be overall search of the institute and hold the office for period not exceeding 5 years at a time, lordship. Yes, because there was a fall on, today I admit there was a fall on the part of the Ministry of Health and Family Welfare, lordship. After taking over the institute, they never left behind, lordship, what is going on in that institute. With apology, I am saying, I should not say this, but after going through everything, lordship, the ministry is sleeping over it, lordship. If properly they have monitored at that time, lordship, all things are not happening, lordship.
Not exceeding 5 years.
Not as per our High Court, lordship, we go by the decision of our High Court, Division Bench High Court, which is attained finality, lordship. And it says that it's a 5 years period, lordship. Then, lordship, paragraph 25, lordship.
Yes.
The superannuation age of a faculty staff is 60.
Seen this.
Lordship.
How many
Now,
times we'll see
now,
this?
lordship, sorry, I'm sorry, lordship. I'm extremely sorry. Now, one of the basic and fundamental argument of the petitioner's side is that he is a director professor, lordship. Whether he can be a director professor at the same time, lordship.
That is not an issue in this proceeding.
Lordship, this is one of the issues. If he is a professor, then he is claiming that I am a professor, so the government of Assam's notification will be applicable in my case. This is their basic argument, and on that basis, that particular order was also issued by the Honorable Court in the first day itself, Lordship. He is claiming is that I am a professor. That's why the enhancement of age, which was done by the Office Memorandum of the Government of Assam, is applicable in my case. This is one of the basic and fundamental argument of petitioner.
This court will have to see on in the year 1999 what was the post. That is the joint director post.
That is the joint director post. That is admitted fact. But argument from the petitioner side is that he is the director professor. Whether he can be a director professor or not, I will rely on the judgment of the Honorable Apex Court. Dada. Right. 1996, 10 SCC 74.
1996.
10 SCC 74.
This was earlier also handed over. I find a copy of this.
Probably we have handed over.
Yes, it's already there.
So, Lordship, I am relying paragraph 9 and paragraph 10 onwards, Lordship. Paragraph 10 and 11. From 9 I am starting, Lordship. Paragraph 9, Lordship. The contention of C. Jetli is that since the appointment to the post of director is a temporary basis, the appellant cannot be allowed to leave his lien in the department post held as professor and head of the ENT department. We do not find that his contention is justified. Here is a case when the government servant is either on deputation or on lien or on any other assignment during the absence of his service on the post. He cannot be allowed to leave without the lien upon the permanent post. On his appointment as a director, which is the permanent post and a tenure post, he cannot continue to hold his parent post, namely, he cannot be hold two posts. Directors as well as the professors of the head of the ENT department simultaneously in this case, the FR 49 is relevant. A government servant lien on a post shall stand terminated on his acquiring a lien on a permanent post, whether under the central government or the state government, outside the cadre on which he is born, Lordship. He is now the petitioner is a permanent in the Lordship that director post, Lordship. So, Lordship, paragraph 10, Lordship. It would indicate that on appointment to a permanent post, to be it under the central government or a state government, outside the cadre on which he is born, his lien on the previous permanent post stands terminated. On his acquiring a lien in the permanent post, the post of director is not in the same cadre as the post of the professor of the AIMS. My Lord, kindly mark it, Lordship. The post of director is the head of the AIMS and it is independent to all the departments. Here also, the post of director is an independent post, Lordship. He is the executive head of the Lordship particular institute, Lordship. He is overall control of all the department of that particular institute, Lordship. The post of director is the head of the AIMS and it is independent of all of the departments. The director is enjoined to supervise not only the administrative work of AIMS but also its management for and on behalf of the institute body, Lordship. Here also his function is to, Lordship, management all the departments, Lordship. He has to look after all the departments, expenditures, all the departments, all development activities of the whole institute, Lordship. Therefore, on his appointment to the permanent post as a director, he lost his lien on the post as a professor and head to the ENT department. Resultantly, when the tenure of the appellant has expired on or by a flux of time, or in the case of any of the eventualities mentioned in the regulation 30A had happened, he cannot revert to the post of professor and the head of the department. It says that as and when your tenure is over as a director, you cannot revert back to any post. Even, Lordship, today suppose he is for a moment he is entitled to the benefit of OM issued by the government of Assam. As per the dictum given by the Honorable Apex Court, Lordship, in paragraph 10 of the Cocker case, Lordship, it cannot be reverted back to that particular position, Lordship. He have to go, Lordship. After the completion of the tenure, or completion of the superannuation age, Lordship. Then, Lordship, paragraph 11 also, Lordship. Same thing reiterated, Lordship. In Dr. L.P. Agarwal case, it is seen from the facts that the Dr. Agarwal came to be appointed as a professor of ophthalmology and the director of the institute. It was a composite appointment. Thereafter, when he was a compulsory retired as a professor, the question arose whether his tenure post of the director had also automatically come to a terminus. In the behalf, this court had considered the question and held that para 16 that even an outside, not an existing employee of the AIMS can be selected or appointed to the post of director. Can such persons be retired prematurely, curtailing his tenure of the 5 years? Obviously not. It would thus be clear that an incumbent appointed to the post of director is governed by the fundamental rules and he is independent to the tenure which he holds in any other post, either on a permanent or temporary basis, Lordship. Accordingly, on his ceasing to the director, he does not have a right to fall back upon to the previous permanent post held by him as a professor or head of the ENT department.
Okay, you noted.
Lordship. Now, Lordship, as per our High Court Division Bench judgment says that you go by the constitutions or rules or regulation, Lordship.
Anything else?
And in that particular point, I have a one recent judgment of the Honorable Apex Court. I have the live law, otherwise in the SCC online also. I will give the citation of the SCC online, Lordship. My Lord, may kindly mark it SCC online part, Lordship. SCC online is 2023, Lordship.
SSC is
2023.
2023.
SCC online.
Yes.
SC 996, Lordship.
SC 996.
In SCC online, Lordship, the paragraph should be 45, Lordship.
45, okay.
And in live law, it is paragraph 44, Lordship.
Justice Pardiwala.
Justice Pardiwala, Lordship. Paragraph 44, internal page 21, Lordship.
Yes.
The age of superannuation is always governed by the statutory rules governing appointment on a particular post. My Lord, may kindly mark it. Hence, even if it is averred that the nature of work involved in the two posts is similar, the same cannot be a ground to increase or alter the service condition of.
Repeatedly, this court has been asking that at that time, what was the age of superannuation?
Yesterday, it is given.
That is why.
It is given.
That is why I don't understand why so much you are taking this here and there.
No, no,
because that is the only issue from how I am seeing. It is clear.
No. Our High Court.
It is only that.
Only
what
that,
is the age that time?
That's why I am saying, Lordship.
Now, suppose that age at that time was 60.
Lordship.
Today, for some reason, you are making it below 60.
Lordship.
Then, of course, it is detrimental.
Lordship.
Which you can't do.
Lordship.
As per that clause 6.
Lordship.
But if it is more, that is not
more,
detrimental.
it is more, Lordship. At the relevant point of the 50
Yes.
years, it was enhanced to 59 and subsequently 60, Lordship. And
it
as
has,
per
it has
the
clearly come out that they are not under the encadrement of
Lordship,
government of India.
And
they are employees of this institute, this society.
Lordship.
But the pension, they are covered under the government of Assam.
Government of
Correct.
Assam.
These are the
Basic,
main issues.
Basic issue. And the paragraph 14 and 27 of our High Court Division Bench judgment, it says that the service condition will be governed by the Constitution. And paragraph 44 of the
That is why it says in that constitution, you should not have any clause which will be detrimental at the time of end.
No, Lordship.
That is why that is
Lordship.
there.
And that was never, Lordship, degraded at any point of time, Lordship.
That much I have understood.
That point. So, Lordship, as per the Division Bench judgment, Lordship, as per the Constitution, so paragraph 44 of the recent judgment of the Honorable Apex Court also says that the age of superannuation is always governed by the statutory rules governing the appointment on a particular post, Lordship. Hence, even if it is averred that the nature of the work involved in the two posts is similar, the same cannot be ground to increase or alter the service condition of an employee, as each post is governed by its own sets of rules, Lordship. So here rules is constitution, Lordship. Constitution, if we taking age of 65 years, then he has already completed 65 years, Lordship. And now we have appointed one person as a director also, Lordship. This is my humble submission before your Lordships.
All right. CGC, no?
Yes.
Lordship,
CGC.
May it please, Your Lordship.
You want to say something?
Yes, my lord. I was included as respondent number 8.
For?
My lord, I am
8 is, who is 8? Private respondent.
Private. I'm associate. I will say associate professor. my lord.
You are an associate professor. You have been impleaded. Yes.
So,
You are supporting the petition or you are opposing the petition?
opposing, also opposing.
You're opposing.
Yes.
How are you affected?
My lord, I am with aspirant for the post of director. Even I was considered in zone of consideration also, but because of impediment in this case, so I was terminated as compulsory retirement, my lord, like this under 56J. It is.
You said you are
during this period,
impleaded.
after impediment.
So you sought for an impleadment.
Yes.
In this case.
I want to assist the court only, my lord. And as first thing, my lord, I'm the aspirant for the post of the director. So, as he is holding the post of director illegally, so I am here.
Acha, to that effect.
Yes.
Okay. You have filed an affidavit.
I filed an affidavit, my lord. Already, my two advocates from central government. As well
Anything you want to add?
Add means, my lord, almost all the same. my lord.
Correct. So
Yes.
then I will accept it. You are adopting the arguments of Mr. Saikia and Mr. Gogoi.
Yes.
Correct.
Yes.
And your
Only, my
affidavit
lord,
is
one
there.
paragraph I want to see.
Huh?
One paragraph kindly see me.
Of what?
Yes, my petition.
Of your petition or affidavit?
Affidavit.
Which page?
Page 170, my lord.
Page 170.
Yes.
Yeah, Dhurbajyoti Chitya.
Yeah, my lord. I want to read, my lord.
Yes,
Yes, paragraph 15, my lord. That with regard to paragraph 14 of the writ petition, the deponent begs to state that clause 6 of the agreement made between Government of Assam and Northeastern Council Secretariat, Ministry of Home Affairs, Shillong, dated 11/2/99, is applicable to the writ petition. Inasmuch as per clause 6 of the said agreement, all incumbent officers and other employees of the institute shall, from the date of commencement of the agreement, be governed by and be subject to the rules set out in the Constitution and bylaws of the Institute hereto as amended from time to time. The post of Director of the Institute is a 5-year tenure post. One can be reappointed, but his term may be 5 years or less, and there is no other provision for appointment of Director for a third or further term. That means he can hold the post of Director for a maximum of 10 years. But in this case, Dr. S.K. Deori, the writ petitioner, is holding the post since 1999 till date, that is 25 years continuously. Next page. It is to be stated here that initially Dr. Deori, the writ petitioner, was appointed officiating director in 1999 as per provisions of clause 21 of the Constitution of the Institute, and consequently every 1 year till he was appointed on a regular basis by office order dated 24 June 2002, Annexure 5 of the writ petition. While forwarded, A copy of the said letter to Dr. S.K. Deori specifically mentions that the words officiating director, LGB Regional Institute of Mental Health. So, as it does not mean, it does not mean that Dr. Deori's service was absorbed into a non-tenure post. The Constitution and bylaws of the Institute was framed and approved on 25/5/99. The writ petition also stated this in page 15 of the writ petition.
Is there an appointment
Yes.
order anywhere there
Yes,
on
officiated,
record?
my lord.
Yes, my lord.
It's there on record.
Yes, yes. My appointment order as director. Yes.
There, my lord, the letter it was forwarded to the director as officiating director. But that letter, that appointment letter, it is regularized. That means he is regularized as director, officiating director. Earlier he was officiating director.
So he also admits.
Okay, it is a tenure post.
My lord, let me first deal with the state government's perspective. Then I will come to central government's perspective. My lord, if your lordship would kindly take the affidavit filed by the state, because I find, my lord, a lot of arguments have been made, both the council representing, which are beyond their pleadings. At least I can say, my lord, my friend Mr. Gogoi has argued 95%, which are not part of the pleadings. This is his own perception. Rather, it may be said these are all legal submissions. That is not the stand of the Government of India, Ministry of Health and Family Welfare. Okay. Because when my learned friend says on right hand side the signature of the petitioner appears, on left hand side whose signature is that? That is Secretary, Government of India, Ministry of Health and Family Welfare. That he will not say. The left hand side signature is that of the Secretary, Government of India, Ministry of Health and Family Welfare. That he will not say.
Which
Please come to the affidavit, my lord.
Yes.
I'll just only one small paragraph.
No, it's all right.
Please come to page 67.
Page 67.
Yes.
Yeah, this is R4, right?
Yes.
Affidavit.
Yes.
Yes, 67.
Now please come to para 11 on top.
Yes.
1.
Yes.
SK Deori was initially employed under Health and Family Welfare Department, but upon taking over of the institute by, kindly see, my lord, Ministry of Health and Family Welfare, he has been absorbed in the institute. So, my lord, there is my learned friend Mr. Gogoi was saying, I am not a director, I am not a professor. Then what I am? It is your perception. That is not the stand of the Government of India, Ministry of Health and Family Welfare. Neither of the state government. It is his personal argument of Mr. Gogoi.
But upon taking over of the
yes,
institute,
kindly, then 3.
No. In 1.
But upon taking over of the institute by Ministry of Health and Family Welfare, that is Government of India, he has been absorbed into the institute. That has been LGBI. Then come to 3. Extension of service under Government of Assam are applicable only to faculty members of medical colleges within the Government of Assam from 65 to 70 years, but not to said institute having been a society registered under the Societies Registration Act, whereas Health and Family Welfare A Department's notification dated 37/16 on retirement indicates age of retirement of allopathic doctor, all cadres is 65. Now, what state government wants to say, my lord, that you cannot take the benefit of this notification dated 37/16 because you are not a faculty member. Am I clear, my lord? So
Yes.
this is the length and breadth of the state government's case. I do not know, my lord. That is not my.
Correct.
I have.
Because
Yes.
Mrs. Saikya was saying that 2 wings.
Yes.
A and B.
No,
Faculty
yes,
comes
I
under
never
B.
disputed that I originally belonged to Health A Department.
I think that was what Mrs. Saikya was
Yes.
indicating.
In fact, my lord, the teaching staffs are in the Health B Department.
B Department.
But in this case, because of the subsequent developments, as
You
I
have
have placed
been
while
assistant
placing the case,
professor.
my lord, eventually I became a professor.
Assistant
also.
professor.
Yes. No, associate professor initially,
Associate professor.
then professor. Yes. Now, my lord, so as far as state government part is concerned, I think I can conclude here because there beyond this, state government has nothing to say in this case.
Okay.
Now, I don't know.
Mr. Chaudhary, when you give me those the synopsis and all, please give these documents in sequence.
Yes.
Your appointments,
sequence.
your
Yes,
promotions,
Yes.
from
Everything.
associate to
Everything.
professor.
Yes. Yes.
Yes.
Now, my lord, will kindly take my friend Mr. Gogoi's argument. My lord, he is contradicting himself. Now, my lord, just to bring home my point, please take the affidavit of the Government of India. Page number 166. My lord, state government stand has been belied by Government of India, by nobody else. I need not. Please come to page 166.
Yes.
Roman 7.
No, this is a different one. I don't know, that two 166.
My lord, the
for which
one
I
with
keep getting
subpara
confused.
7 and 8.
One
Roman.
second, one second. I know, I've got it. Yes, now I have.
Department of Expenditure.
Huh?
Starts from Department of
No, now I got it. But actually, there are two 166.
Yes.
So,
Classification.
yes.
Now, please come to Roman 8.
25 clause.
Yes. That clause 25 of the Constitution are set out below for ready reference. Tenure of service. The superannuation age of faculty staff is 65. For non-teaching specialist doctor is 62 years, and for other staff is 60 years. So I have been made to retire, which is the subject matter of challenge in the first case, because as a faculty, I attained the age of 65 years. So therefore, I should retire. Now, it's a different question whether I'm entitled to benefit of the other circular. So, my lord, Government of India has clearly defied what Government of Assam is all throughout saying. So, Government of India's case is, no matter what my learned friend Gogoi may argue, Government of India's clear-cut case is, you are a faculty member, you have attained the age of 65 years, therefore, in July 31st, 2024, you should retire. That is on the challenge in the first case. So, my lord, central government itself says, Mr. Assam government, he was speaking certain things which is not correct. This is the actual position. So, Assam government stand is taken care of by Government of India's affidavit.
All right.
So, my lord, is absolutely clear. Now, let me deal with the points which my learned friend has raised. Now, my learned friend says that decision of Government of India, Ministry of Health and Family Welfare is binding. Who is disputing, my lord? Have we ever disputed? Nobody's case. Government of India, yes, of course it is binding. Now, the another contradiction is, my lord. Now, please take the affidavit of the Government of India for a moment, my lord. The same page. The subpara of Roman 8, that the petitioner had accepted the offer of respondents and therefore he will be covered under the Constitution and bylaws of the Institute. The Government of Assam notification raising the retirement age of faculty will not be applicable on the petitioner, as neither the petitioner is an employee of Government of Assam and neither has any lien on the service in the Government of Assam after accepting the offer of the respondent. Further, it is submitted that no action has been done by the respondent against the petitioner by which he can claim that services of the petitioner has been altered or the petitioner has been put into any disadvantage or action of the respondent creates any hardship on the petitioner. Then please come to me, Lord, para 10, Roman 10. The Ministry of Justice and Law, Department of Legal Affairs has opined that Government of Assam notification dated 31/8/22 enhancing the pensionable age to 70 years is not applicable to the petitioner, as petitioner being an employee of an autonomous body of the central government, that is Lokaprio Gopinath Bodlo Institute, Tezpur. So, my lord, in this paragraph, apart from saying that the petitioner is a faculty member, therefore he is liable to retire at the age of 65 because he is governed by the institute's constitution. Secondly, it says, since I do not have any lien over the Government of Assam post, therefore I cannot claim the benefit of this 37/2016 circular as well as 31/8/22 circular, which gives the benefit of, my lord, enhanced age of 70 years in case of faculty members. All right, let us accept for the time being. Now, my lord, what about page 61 and 2 of the writ petition? Please come to page 61. That the government of India has not dealt. Please come to page 61 of the writ petition, my lord. My learned friend, by referring to 3.2, argues that I do not fall in any of these categories. But
This
what
is
will
the
happen to
NMC.
7.2 at page 62, my lord?
NMC.
Page 62 or 7.2?
Yes.
7.2.
Persons appointed as
Person appointed as teaching faculty during the transition period shall be eligible for promotion to the post of associate professor, even after the transition period of 10 years are over. Such person shall also be entitled to hold teaching position held by him until the age of 70 years in the same or any other recognized medical institution. So, my lord, am I not entitled to a consideration on the days? On one hand, government of Assam has washed his hand off. If government of India also wants to wash his hands off, where do I go? Now, my lord, please come to page number. Why this?
Your case is that in the transition period you've been appointed as an associate professor and then subsequently professor.
Yes, my lord. For that, I'll just refresh my lord facts.
And
my lord.
this document.
Just 2 minutes. Yes, my lord.
This document.
Yes,
NMC
definitely I'll do
document.
in my thing. For your lordship's kind perusal, I'll just place it. My lord will kindly have page number. Yes, page number 138.
138.
Yes. My lord, this is a part of the report of the empowered committee. Page 138E.
Yes.
All recommendations to the medical faculty post shall be as per MCI guidelines. Now it is NDMC. Now, my lord will kindly come to the next page. Now, my learned friend says, I am neither director nor professor. This is not audible to him, my lord. Kindly see 139.
At page 133, who is this chairman?
Where, my lord?
Committee at page 133.
133, my lord.
Yes.
1 second.
This is some recommendation.
He is the then chairman PL Thanga empowered committee.
He is the governor of the Mizoram at the relevant point of time. And was one point just
Mr. Gogoi, please take your seat. Yes,
Please come to 139, my lord.
139.
Post conversion annexure 2. Solendra Kumar Deuri, that is the petitioner, kindly come, my lord, to the present position, Joint Director of Health Services Assam. Additional responsibilities being held in addition to the regular duties, Director, Associate Professor and Head of the Department for all the academic departments / Medical Superintendent. Proposed allocation, Director and Professor of Psychiatry.
And this is given by whom?
This is by the empowered committee, Miller, of which this gentleman called Thanga was. Miller, I am a member secretary, therefore my signature would be there. But what matters is that one who presides over it. And these are not my individual decisions, my lord. Now, my lord will kindly come to page 144. Yes.
Yes.
It was prior to that agreement, my lord. At one point of time, health and family welfare took over. At that point, it was donor. As per recommendation of the Departmental Promotion Committee held on so-and-so, it is to inform you that S.K. Deuri, LGBA, has been conferred the status of professor in the institute with effect from 26th of February 2006.
So right now you are a professor.
I'm a professor. I'm a professor director.
And this is by the donor.
Yes. Now, my lord will kindly come to page 145.
Yes.
This is the prospectus of the institute, my lord. if your lordship would kindly come to 146.
Yes.
What all are the courses offered? Psychiatry, clinical psychology, psychiatric social work, psychiatric nursing home, nursing, etc., etc., etc. So these are the courses which are being offered by the institute. Now, my lord will kindly come to page 148.
Yes.
Now, my learned friend says, I am neither director nor professor, but the institute recognizes me as professor director at page 148.
Designation.
My lord, in the peculiar facts, I am, my lord, holding both these posts because I was given a non-tenure post. Yes, LP Agarwal's case, that's a correct proposition. Because once you complete the tenure, then you'll have to go back. That LP Agarwal's case, which my learned friend read. Then my lord will kindly come to page number 151, my lord. Oh, not important. My lord will kindly come to page 158. Now, when the question of, my lord, the petitioner's tenure came, then what was the decision taken? Kindly see, my lord, the matter of proposed amendment in the bylaw under section 20, that is Constitution, my lord, Article 22 and 3 concerning tenure of director of the institute was taken up for discussion. The members were unanimous to the fact that matter of revising provision of bylaw has arisen due to an extraordinary situation and it needs to be addressed without delay. When institute was under the administrative control of the government of Assam, the director of institute was appointed to a non-tenure regular post, and if the post is now made a tenure post after it was taken over by government of India, then incumbent will be without a job after completion of his tenure. The incumbent director was absorbed into the government of India fold as director of the institute after taking over. The members noted that director is a qualified psychiatrist and has more than 10 years of service left. The honorable chairman proposed that incumbent director may be regularized in his services till the date of his superannuation, as it would not be proper to change the rules to his disadvantage due to the takeover by government of India. Now, what more is required, my lord? And at page 159, left-hand side, that is the signature of the secretary to the government of India, Ministry of Health and Family Welfare. He is the chairman, my lord, of the executive committee. On left-hand side.
He is who?
He is the secretary of the government of India, Ministry of Health and Family Welfare. Now, my lord, an argument has been made that we are an autonomous institute, therefore these NDMC guidelines are not applicable. Please come to 160. The 28th meeting of the Executive Council of LGBI was held in the first floor of the conference hall, New Delhi, on 4th November 2019. In view of absence of Secretary Sri So-and-so, was elected by the member of the Executive Council to chair the meeting of the Executive Council. The following members attended the meeting. Now, please come to page 161, my lord. Please come to serial number 8 towards the bottom. Experience criteria for assistant professor in LGBRIMH as per newly approved pay scale. Now, what they will follow? Institute to follow extend instruction of regulatory bodies like NMC, which is there at, my lord, page 60 and 61 of the writ petition. So, my lord, when it comes to how we will make recruitment of assistant professor, then you will say, no, we apply this. And when it comes to determining my entitlement under clause 7.2, then you will say, no, 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 no. You are an employee of the institute, therefore this does not apply to you. Well, this is what has happened. But these things, my lord, are not in pleadings. These are all. Now, my lord, on the basis of these facts.
Well, NMC is page.
Yes.
I'll just write down here.
Yes, my lord. NDMC is page 61.
60. Okay. There, you were relying 7.2, right?
I'm relying on 3.2 and 7.2.
Yes.
Now, my lord, Assam government says since you are governed by an constitution of an
It's like blowing hot
institute,
and cold.
so I can't, all right, accept it. But Government of India can't say, at least I'm a faculty, my case should be considered. So where is the question of, my lord, when I have made out more than a prima facie case to deny an interim relief to me, my lord, in the second case? Now, my lord, let us, one more point of my learned friend. He says, my lord, it's an autonomous body society. So NMC is not binding. That's not correct. NMC is binding on you. You have accepted it. You are following it. Now, if we accept that argument, then as a government of, if I am supposed to be governed by Government of India, Ministry of Health and Family Welfare, and I am in society, then I am not governed by this Government of India. I am supposed to be an autonomous body. End of the matter, my lord, my administrative ministry, our administrative ministry is Ministry of Health and Family Welfare, Government of India. So, my lord, I have a right that as a faculty, I have a right to be considered either by the state government or by the central government. Now, it can be that I shall not be considered by either of them. This is my case, my lord. Now my learned friend is referred to, my lord, the judgment of the Supreme Court in 1996 10 SCC. Well, how that is applicable in this case? And my learned friend was referring to this division bench judgment again and again. Please come to the facts of that case, my lord. Please come to that Guwahati High Court division bench judgment, 2012. Please come to the very first paragraph. Whether appellants herein, who are both doctors, stood absorbed unconditionally and absolutely in the service of LGBI Institute on the strength of office memorandum dated so and so issued by the directorate, is the principal subject of controversy in this present appeal. Now, how a decision is an authority for what it actually decides. Now, if the facts of those observations were made, yes, if I would not have had Government of India not come up with this page 61 notification, then yes, I would have retired at 65, in which case, my lord, this will apply to me. But now the fact that Government of India is extending the services of faculty to 70 years, how I can be, my lord, not considered? Normal circumstance, yes. I am governed by that constitution. I never said I will not be governed by. But to say that the benefit of that notification will not be extended to me, that is an issue which falls for to be decided. So in this fact situation, my humble submission is, my lord, that this subsequent order by which, my lord, now another person is sought to be appointed, that should be stayed. I am holding as on date.
According to you, that constitution is not applicable to your case?
No, my lord, I don't say constitution is not applicable. What has happened in this case, my lord? Now, I refer to that 249-page letter, my lord, where it was said that I, as an inherited employee, were treated separately. My lord, that was primarily in the context of pensionary benefit. Subsequently, it appears that, my lord, it was decided that the pensionary benefits would be given in accordance with the Assam government rules. So that is an issue decided. But what about the other service conditions?
Can we come back to page 30 for a
30,
moment?
Miller.
Clause 6.
Yes. Yes.
Can you please read it again?
Yes. All the incumbent officers and other employees of the institute shall, as from the date of commencement of this agreement, be governed by and be subject to rules set out in the constitution and bylaws of the institute hereto, as amended from time to time. All existing employees will be given choice of absorption in the new setup or reversion to the government of Assam. The terms and conditions governing such employees serving and employed by the institute shall not be to their disadvantage. Well,
What do you understand?
Yes, in my humble understanding, my lord, once we are taken over, then ideally we will be governed by terms and conditions set out in the constitution and the bylaws. But while doing so, care should be taken to see that service conditions are not such as will be lesser than what we were getting under the government of Assam.
No, because it seems
yes,
this is just not about the serving, but also the one employed. Because if you see the opening
Yes,
sentence,
no, my lord. It says terms and conditions governing all employees.
correct.
Yes.
And if you see the opening sentence,
all incumbents,
and it says, and other employees of the institute shall, as from the date of the commencement of this agreement, be governed by and be subject to the rules set out. That means it is not yet
On
set
that
out.
day it was not
Correct,
there.
Correct. Set out in the constitution and bylaws of the institution hereto as amended from time to time.
Yes.
So at that moment,
It was not there,
it was
subsequently
not
it has
there.
come.
All the existing employees will be given, this is relating to you, all the existing employees will be given choice of absorption in the new setup of or reversion,
Or reversion to the
switch.
government of Assam.
Then it says the term and conditions governing all employees serving and employed by the institute shall not be altered to their disadvantage.
All means, my lord, those who has opted, means those who opted to serve in the government, in the institute,
and the ones that they have been employed.
Their
Both.
condition of service will not be such so as to be demeaning of what they were getting under the government of Assam.
Because if I may be wrong, I have to read again.
Yes.
But the perception that I am building out of clause 6 is that if I read it together,
yes,
because at that moment when the servings are there and they are employing new one, the constitution has not come.
No.
So nobody knew what terms will be set out. So it is mentioned that tomorrow when the constitution comes, if
the
there
conditions should not be such.
Correct, that it would be contrary to
what they were getting earlier.
Correct. To both, because the appointment order might have some terms, something may be there. So tomorrow by
So my lord, let us
constitution
apply
you
this.
cannot
Now
change
let us test this argument, my
Yes,
lord.
yes.
Now subsequently constitution came up.
Correct.
And constitution says for faculty member
Yes.
retirement age is 65.
65.
Very well. There is no dispute. But that is not against the my lord. That is not of any disadvantage to me, because under the state government also at that point of time it was not 65. Now, my lord, what I am saying is now government of India has said that faculty members would also be entitled to 70 years. Assam government stand is very.
So in other words, you are drawing a parity. You are trying to say that since the persons similar to you in government of Assam doing similar job is their age has been enhanced to 70. Why not mine? This is in other words, this is your
yes, and government
correct.
of Assam's perspective is, my lord, you should not get it because you are not faculty, which is not correct.
Because you are already given
Yes.
associate professor,
No,
professor.
my lord, the government of India itself says in their affidavit says a faculty retires at 65. That's why I was made to retire. at 65.
So the factum that you are holding a faculty post is not in dispute.
Yes.
By the government of India.
So therefore, my humble submission is, my lord.
Who is the authority who had taken this institution? The institution merged with them.
So therefore, my lord, the government of India stand today is twofold. That you have attained 65 years, therefore you are supposed to retire. And government of India has not said why it will not apply that government of India notification to me.
So have I understood your argument?
Yes, yes,
correctly,
absolutely.
Mr. Chaudhary?
Absolutely.
Twofold, isn't
Absolutely.
it? First is as per this, and then you're drawing that
Absolutely.
parity. You're not saying that because I should have got this, that
No,
is not
no.
because of the parity.
That is my case, my lord.
And
Only thing is, my lord,
there's just one clarification.
Yes.
Mr. Gogoi had relied this decision of the Guwahati High Court in bench, and from para 27.
Yeah, it's what it says that in case of any headache, it will be governed by constitution.
Yes.
Very well. My lord, I'm not disputing that. Question is,
But
apart
that-
from the constitution, there is a government of India circular which extends that to 70 years.
Mr. Chaudhary, now I have understood.
That's my humble submission. And what I'll do, my lord, I'll give a
that would be
not
important.
today, my lord, Monday, lord, we'll get
Because then I'll post it on Tuesday.
or Tuesday, my lord. Yes.
But if you can give it to me in advance, it will be on Monday if possible.
Monday,
Otherwise,
actually, my lord, Monday I'm in Delhi, my lord. I'll come back only.
No problem.
There's a case
Tuesday.
in Supreme Court, so I'll go Sunday.
Now, in that motion case, there who are you? You are holding what post in
No,
that?
my lord, in that now what they want to do, they want to appoint somebody as in charge director. I have challenged that.
In that motion matter.
Yes, in that motion matter.
But here you are already, he's already holding this
Yes.
post.
No, my lord, in the earlier interim order, there was a rider that stay in respect of faculty, my position was protected. Regarding my lord, what do you call it, director part, it was
That
kept
was
open.
kept.
It was kept open.
Then, with all fairness, since I'm hearing this matter, let it be together. Let us get into a verdict first, because it will not be proper. I was thinking it is some another petitioner who also won. That I did not.
Same petition.
So I'm keeping 3 matters.
Yes.
Where is the time? I have kept one bail matter for disposal. Yeah, we'll try it. But the outcome of this case perhaps will have some bearing in your case, because you were telling me, if I recollect, the other day you said you've been compulsory retired by the petitioner or something.
I was trying to say is there was a disciplinary proceeding against me.
But it
There was a disciplinary proceeding against me, and I was contesting that disciplinary proceeding in another petition. A second disciplinary proceeding was initiated against me. In the meantime, the superannuation of the Dr. Deuri came in. 31(7), he is declared not to be continuing in the post of director, only the post of professor is protected. He passes a compulsory retirement order upon me on the basis of the inquiry report on 5/9/2024.
And if suppose we held that that he superannuated at 65, then this goes.
Then this order automatically everything will
Correct.
go. So therefore, madam, what another aspect that I was trying to say is, while all the arguments were going on, Lordship felt that there was
In that case, your compulsory retirement order becomes void. If we hold that,
yes, and even if I don't go for
just a counter, Lordship. Even Lordship, central government Lordship with effect from 1st of August Lordship 2024 Lordship, he was released from post of director. And from the 1st of August Lordship, there is no post of director Lordship. He even cannot sign a single document as a director
but
Lordship.
your thing is
But he has
signed when?
passed the order
5th of September.
5th of September, he has passed
yesterday
the order.
also, yesterday
Prima
also,
facie Lordship, it is absolute violation of the Honorable High Court's interim order Lordship. He was
Wait,
not
Mr.
protected.
Gogo, you also give a detailed.
Lordship, I'll
You can give it like a pointer
Lord,
sequence.
I will just bullet point. I will
Yes,
give
yes.
Lordship.
Just
Only
give me
bullet
that
point.
bullet point, and if you are referring to particular document, just
Lordship,
mention page number.
Lordship, only bullet point and page number. I will
That is sufficient.
Lordship.
Because otherwise it's very
Lordship,
difficult.
very
You see?
difficult. Otherwise, Lordship, on the point of in his case, Lordship, Government of India stand is that the person who is no more holding the post of director, he cannot issue a Lordship order.
That is obvious. If this court comes to a finding that he had already retired, then any order signed after retirement will all become void ab initio.
Even Lordship,
correct.
The single bench
there was
judgment.
a prayer for
Single
interim.
bench. The single.
You have an interim.
Single
You
bench.
have a prayer for interim.
The single bench judgment Lordship, which was passed by the Honorable our
Where
High
are
Court.
those matters, bail matters gone?
Single bench judgment only protected
I'm
his.
seeking it. Wait. No, Mr. Gogo, I didn't ask you to.
Oh, Lordship, I think Lordship.
No.
Lordship, in the
You do one thing, you give me that detailed thing.
Lordship,
I'm taking it up, I'm posting it on Tuesday.
Lordship.
As far as Mr. Majumdar's matter, we are not doing anything right now. Let us first take a grip of this. But you are open to give me a written synopsis. Because you see, if it is interlinked, at the time we take a final call in this, perhaps your case can also be considered. So just give me a written.
What I had prepared was
You've already prepared.
not a brief. All the documents in all the petitions, including mine, I have got a compendium, and it will fill up the gaps.
And
appreciate
given madam just 2 minutes time, and just show how I'm filling up the gaps. I will not argue much, madam.
Yes.
Lordship will initially find the date list. On the first page is the date list. First part is the date list, madam. Now here this is the person is the client of Ken Chogiso. Now if Lordship would kindly come to page 1, 4 pages below. This is how I've tried to make it. This was his first appointment to the
Where?
Page 1, my lord.
No, first page.
The first page, first, second, and third, fourth page. These are the list of documents that I have given.
Where is the appointment you just said?
Page 1, the first appointment that we could get our hold of. And these are all documents.
Date, just give me the date.
5th of August 1987,
87.
he comes in as
Deputy Superintendent.
Deputy Superintendent in the rank of MHO.
In the rank of
MHO, that is a Medical and Health Officer. Then Lordship would find at the next
and this
page.
document you have annexed at, enclosed at one.
Oh yes. No, the documents are there differently in my petition.
All right, but
they
here-
are all there.
But in this compilation,
Yes,
it's not
yes,
it. So,
Now
so you
Lordship
have
will find
you have solved
a lot of
half
problems.
of my anxiety.
The documents will be here.
All right.
Now, if Lordship will find page 80, the next page, page 2, he comes in as under regulation 3F as
Same
the
post.
superintendent.
Same deputy superintendent, but Tejpur Mental Hospital.
Okay. Then page 2 is he comes in as the 3F.
The 3F.
Then page 3.
3F is an ad hoc.
Malab?
3F.
Yes, it is just given someone.
Ad hoc, right?
Per month period is extended time to time loss.
So now at page 3, Lordship will find that is regularized.
All right.
Now these are documents which he had given in earlier petitions.
As superintendent.
Yes, and he has given these documents in earlier petitions, certified copies.
Okay.
No doubt on it. Now Lordship will find at page 4, the first Board of Administrators
Assume
meeting.
charge. Yes.
So page 4, they assume charge.
Yes.
Now the interesting part, page 5, the
Yes.
first sanction order of the NEC. That
Six,
it will
page 6, I think. 18/12/97.
18/97, my lord.
5 or 6? I think 6. Page 6.
I'm so sorry. It starts with sanction order, Lordship finds.
Yes, yes.
That one page might be up and down, my lord. I'll just correct it by
Here
opinion.
it is 6.
The first page must have gone down. So it might be page.
Oh.
Is it, my lord? Perhaps.
No. 4 and 5 is a continuation in my compilation. Anyway, let's not get into
All of that. So now
you
Lordship
are
will see-
relying to 18/12/97.
Yes, Lordship will find
Sanction
sanction
order.
is hereby accorded. The first paragraph, Supreme Court order is referred to. Then
This
minutes
is
of the
1997.
yes, my lord. Lordship will find Supreme Court order is referred to the
Achha,
reference
this is the sanction for taking over
Yes.
the institute.
by the NEC.
All right.
Now Lordship will have the next page, the continued page. Fourth
Yes.
para Lordship has
Yeah, no,
all proposals.
I think you may have missed out one page.
Just check out. Lordship will give me one. This.
I think one page has been-
No, no, if you do permanently video, permanently. Lordship will
No, I know what has happened. It is just interchanged. I've got it otherwise.
Lordship, that is the corrected one.
Like yesterday's my
So
affidavit.
sorry.
What had happened to your affidavit is happened to this compilation.
Same.
So Lordship will have page 5. This is the first sanction order.
Yes.
Sanction is hereby accorded to the Northeastern Council to take over the LGB mental health, Tejpur and develop it as a.
That I have seen.
Then Lordship will have para 4
4.
on the next.
All
All proposals for upgradation, modernization, expansion of the institute, as well as those for creation of posts. Lordship will just mind creation of posts. Now this is December 1997. The next page page 7.
Yes.
Now Lordship will find the first time he was given the associate professor. The first item.
This
Minutes
is
of the
19?
this is 27/1/1998. So that is 1 month later. The minutes of the 12th meeting held on 20/12/97.
Takeover was when?
18 December 1997 was the sanction.
Sanction.
98, 1 month later.
Memorandum was signed in 1999.
9. So now in the interregnum, when just a sanction has come, what the Board of Administrators does is, minutes of the 12th meeting held on 20/12/97 be and are hereby confirmed subject to the modification at item number 4, that the member secretary will be in charge of the diploma of psychiatric nursing. Now, you will see a nursing unit is given to him. With the status of an associate professor, the post being created hereby. So this creation of the associate professor post itself by the board is in contravention of the sanction order, which says that it has to be done by the Ministry of Home Affairs. So now he comes, this is the first time he comes in as a
Assistant professor. Associate professor.
Associate professor, and that is where the entire issue now actually hinges, whether he could have been a associate professor. He could not have been, because the post is created without the sanction of the NEC. Now this is what if I may say so, I remember Oliver Twist. What happens is they gave birth to a child, they forgot about it.
Look
Now,
like
Lordship-
it has happened.
Already I am in
Now-
legal, Lordship.
Now, Lordship would kindly have page 18. Rest I will refer later on, my lord, the agreement and everything.
Page 18.
The lien part. What has been argued? Page 17, Lordship would have first. Page 17,
Yes.
Lordship would have first.
Yes,
17.
I have.
With reference, this is written by the Government of Assam Health and Family Welfare A Department. With reference to your letter above, I am directed to say that your proposal for granting deputation or lien to the employees of the institution has been examined. The government have no objection to the grant of lien to the eligible employees initially for a period of 1 year. You are therefore asked to requested kindly to ask all regular employees of the institute, both gazetted and non-gazetted, to pay for lien. That is how it comes up. Now the lien comes on the next page. Now this was read out to Lordship, one part was not. Page 18, I am directed to say that the Governor of Assam is pleased to grant Quashing lien to the following 184 numbers. Lordship will see 184 numbers of officers and staff of LGB of mental health Tejpur for period of 2 years. Now these 2 years, Lordship will find on the next page, page 19, the first person who got a lien.
Theory.
He is the first person to get the lien. He applied for lien.
Join the HS.
He applied for lien, he got a lien. Then Lordship would have all the other persons. Oh, I'm sorry, my lord. Lordship will see that 8, 9, and 10 persons. He is one. 8, 9, and 10, Lordship will just note. 8 is one S. Roy. 9 is S. Roy. 10 is R.C. Devnath.
Devnath and Medhi.
Read April 20 of 2008. Connected to Read April 20 of 2008. Now, these were persons along with him from the Government of Assam who got a lien. Now, Lordship would kindly come to page 24.
Yes.
The lien of 2 years from 1999 was ending in 2001. February 2001, it was ending.
2 years.
So this is a letter issued by the SK Deuri saying, hereby it is for general information to all employees, officers of this establishment to submit individual application for lien effective from 17 to 2001 for 1 year. He asks everybody to give a application for lien, including him, because he was on lien. That is something like. Now, Lordship would come to page 25.
Yes.
The table form, my lord, the redesignation of the posts. First is the joint director would now be redesignated as a director. Because what was a joint director post in the Government of Assam now becomes a post of director in the institute. Now, Lordship will have 3. The senior MNHO would become an assistant professors in different subjects. Lordship finds. Then the MHNO, deputy superintendent, assistant, and associate professor. Lordship finds. So these are the relations. I am pointing out this because this will have relevance in the Read April 20 of 2008, which was said not to be applicable to him. He is one of them. Now, Lordship should come to 27. Page 27. While creating the posts, what was said? These posts will only be into the central government pay scale. They are not in the central government. It is only in the pay scale. At the corresponding entry level, subject to this being equal or higher than the Assam government. Now, the employees to be fitted against this post in the central government pay scales should fulfill RR stipulation in respect of qualification and experience. Now, 2 points were given. You have to fulfill both. If you want to remain as a professor, assistant professor, whatever, you have to be eligible per qualification, per experience. Therefore, in Read April 20 of 2008, these R.C. Devnath and everybody had to go back. They did not have the PG degree. Now, what happens to the petition? At that point of time, this institute did not have any medical courses. He was granted the status of an associate professor without the experience part of teaching in a post of assistant. I will give those later on, my lord. Now, if he did not have the experience, while throwing out R.C. Devnath, he was one person who was required to go. He hid it from the court. He kept silent. Now, why did R.C. Devnath happen in 2008? 2006, 2002, posts are created. They say 5 years gap. 2007 it is ending. He sends back persons in 2006. those MHO.
But why at those relevant time nobody objected?
My lord, that is why I said
That's why
it
I'm
was
saying,
a
Lordship.
child given birth and forgotten.
That's why I'm saying, Lordship.
Now
Very
I'll come to documents which will show that the MCI has been misled as of today. The Shankardev University Act requires that all colleges or institutions giving any sort of medical training has to be registered, has to be affiliated to the Shankardev University. As of today, LGBIMH, where MD degree in psychiatry is given, is affiliated to Guwahati University. The reason, his wife Sonia Pereira Deuri is the Dean of Faculty of Medical Sciences in Guwahati University, only institution in Assam which is still affiliated to Guwahati University. Lordship will see the impact which is coming, and therefore in WA 20 of 2008, court was very, I'll come to that. Court was very categorical. Public interest is what will prevail over every private individual's interest in this particular institution. This is a case where I'm saying a dead horse is being flogged. Run for me. I need to remain the director, or everything else falls. Therefore, my lord, I was trying again and again to impress that documents are not being fully read. Affidavits are being done on basis of materials available with them. Every petition is a different document, a compendium. Everything will come out. Now, Lordships will kindly have the next
Mr.
page
Majumdar
20.
will continue on Tuesday.
So, my lord, what I'm trying to impress is without hearing me or
of
going
course,
through all these
of course.
documents, my lord.
No, I will not reserve it unless and until I hear you. I will not reserve.
I'm so obliged.
To item number
I'll come back.
Tomorrow 62 to lekha first. 62 hearing. Fix on Tuesday date for further hearing. I'm not saying at 2 or anything right now. We will see.
I will only take an indulgence, my lord. Monday, Tuesday, I have a matter at Meghalaya. I'll come back 10:30 or 11. I'll start from there. I'll be here maybe by 1:30 or 2. That much indulgence, my lord. I'll have it in this.
Or you join from the car. That indulgence also I can give you if required. Now you have that advantage.
My lord, I was once asked in court number 1. I got a stay in Meghalaya High Court, and then I reached on the matter here at around 12 o'clock, around 1 o'clock. And I was asked that you were out of station, mention was made, how are you here? I said, I was in Meghalaya. You can't be in 2 courts at the same time. I'll dismiss your petition. Justice Mia said me that.
True. But now with
the facilities,
you can be in 2 courts. Anyway. So further hearing on 60. And 61 and 60, you just tag it with 62. Don't say anything. Right?
My lord, fix it on Monday or Tuesday?
Tuesday. And it will 62 to provide your 62.
I'll hand over copies to all councils.
Mr. Chaudhry's have you given to me?
So that they can have objections if they want to own any document.
Is that bail matter?
Obliged, my lord.
All right. Did you go through the scanned copy?
Yes, Lordship, and I have accordingly flagged among the relevant pages, Lordship.
Where is the FIR?
My lord, the
Lordship, in the petition, it starts from 15. Lordship.
Page 15.
Yes. And relevant pages will be, the Lordship will find it page 21.
Illegal business of ganja.
Yes, my lord.
Yes, Lordship.
This is the allegation, my lord.
Offenses
20B, Roman 2, C.
It's 20B.
20B, Roman 2, C.
C is there.
Commercial quantity, Lordship.
Commercial quantity.
Yes. Lordship, may kindly come to page 60, Lordship. Rejection order of this.
We proceeded from the pursuant and machine. It was from his possession.
Yes, Lordship.
My lord.
What is the name of the accused?
Ajibur Rahman.
Ajibur Rahman, my lord.
So this contraband articles have been seized from your possession.
Lordship, may kindly see your lordship order, my lord. Firstly, my lord.
Page
it is
60,
page 60, my lord.
Page
60, my lord. On 2 ground, my lord, I have again before.
This is second time.
Second time, yes.
This is second time.
Yes, my lord. Lordship, So I would like to refer page 60, my lord.
What is changed circumstances?
Lordship, can you see, your Lordship has, my lord, rejected my bail prayer on 19/12/2023.
Yes.
Thereafter, my lord, I have approached before the learned court below, page 63, Lordship.
This court rejected your bail primarily on the basis that it was seized
Prima
from your
facie case.
possession.
Yes, my lord.
So prima facie, it appears that you are guilty because of that.
Yes.
Because of that, my lord.
Yes.
So
37 regards.
Yes.
Yes.
Thereafter, I approached the learned court below, my lord, page 63, where I have taken a categorical stand that, my lord, from the record, my lord, the contraband which was seized, my lord, it is not fall under commercial quantity. Though charge was filed under section 20C, my lord, but from the record, from the my lord, the seizure list, and from the charge sheet, my lord, the my lord ganja, alleged ganja, which was seized, it was my lord 22 point something kg, my lord, including the drum, my lord, plastic
How
drum.
can this court go into all this? These are matter of trial.
Yes,
My lord,
Lordship.
that's why,
Trial
my
is
lord,
already going on.
Yes,
My lord.
Lordship. Lordship,
My
may I
lord.
submit,
My lord.
Lordship?
Yes.
Out of 19 listed witnesses, only 3 witnesses has been examined. That only scissor, only 1 witness has been examined, which happens to be the scissor witness, and other 2 witnesses are there, but rest of the relevant witnesses are yet to be examined, Lordship, because at this stage I'm vehemently opposed, Lordship.
my lord, that's
regarding
why
bail,
I have
Lordship.
taken another ground, my lord, because of the long incarceration, my lord. And
What
this
ground?
long, my lord, he is, my lord,
Mr.
jail.
Counsel, this is the second time. There cannot be a review.
No, that point was,
Second bail application
My
is not a review of the
my lord, that
first
point was,
bail rejection.
Yes,
You have to come up with changed circumstances.
so, my lord, the learned court below,
At this early stage of trial proceeding,
my lord,
Lordship, I'm
learned
vehemently
court below was, my lord, appointed that I have not taken the my lord, point of the charge at the time of the framing charge, my lord. My lord, it is the duty of the court, my lord, to see, my lord, under what charge it was framed, my lord. But, my lord, I have some judgment, my lord. Honorable Supreme Court also says that, my lord, when, my lord, there is a contraband was seized, it was, my lord, kindly, my lord.
Those judgments are at the stage of consideration of bail
Yes,
or at the stage of
My lord, that was, my lord,
appeal.
bail, my lord. You see, my lord, firstly, my lord, I would refer to Delhi High Court, my lord. On judgment, my lord.
No. You forget other high courts. Apex court you have?
With reference to the apex court, my lord.
But Mr. Counsel, I'm warning you. There cannot be a review. If it is on some changed circumstances, then I will have a look. Do not otherwise waste the judicial time of the court. Yes.
Yes, my lord. In my lord, the High Court of Delhi, my lord, I refer, my lord, paragraph 13, 16, 21, 23, 26, 29, 28, my lord, 29 maybe loss of defense, my lord. Paragraph 20.
These are submissions.
No, my lord, thereafter bail was considered by Delhi.
Mr. Counsel, first of all, this is a coordinate bench of Delhi High Court. Is this a precedence?
No, my lord.
Is this a precedence?
The reference was cited.
Is this a precedence?
No.
Then,
My lord, Supreme Court-
and you are referring to submissions made there.
So, my lord, law is that, my lord.
What is the law?
My lord, while, my lord, in way of considering the measure, my lord, weight, my lord, my lord, actual, my lord, substance, either it's psychotropic or the, my lord, drugs, has to be considered, my lord. Yes, my lord. Paragraph 29 may be seen, my lord. Only. In reference to Honorable Supreme Court judgment reported in the manner the Arun Kumar
Hira Singh.
What is the quantity?
22.225 kg.
22.225
kg.
225.
including the drum. It is written in seizure list as well as in charge sheet also. And my lord, it was also seized, my lord, from not conscious position, my lord. This petitioner was sleeping in other place, and the team after my lord out of him and seized the contraband.
He was earlier arrested in such kind of activities.
earlier?
Earlier arrested in another cases, Lordship. That is also reflects from your Lordship's order. That is at page 62. Lordship.
He was in bad mind.
Heard Mr.
Jiuddin,
learned counsel for the petitioner. Stop. Also heard MS.
S.H. Bora.
S.H. Bora.
Yes.
Learned APP for the state respondent. Stop. This is the second application under section 483 of the BNSS 2023 for granting bail to the accused petitioner I. Azibur Rahman, alias Aziz, alias Ajibur Rahman, alias Aziz Ali, who was arrested on 9/4/2023 in connection with NDPS case number 103/2023, which is pending in the court of Learned Additional Session Judge FTC number 3 Kamruk M, Guwahati, arising out of Pragjyotishpur PS case number 48 of 2023, registered under section 20B 2C of the NDPS Act 1985. Mr. So-and-so, learned counsel for the petitioner, submits that in view of the delay in proceeding with the in view of the delay the trial is taking to conclude, he is entitled to be released in bail. He further submits that
paragraph 13.
He further submits that from the charge sheet, seizure as well as inventory, it is clearly revealed that from possession of the present petitioner, contraband articles measuring 22.225 kgs was recovered. He accordingly submits that the drum definitely ought to be a big in size one and ought to weight about more than 4.5 kgs. So after deduction of weight of said drum, the case will be under commercial quantity. Where you said possession, clearly revealed that from possession of the present petitioner recovered one blue color plastic drum wrapped with blue color plastic tied up with coconut rope measuring weight 22.225 kgs. Para 13 not where is it mentioned here? Because he's saying this drum has been also weighed together. Is it correct?
Lordship, yes, that is reflected in the charge sheet. But Lordship,
where? It is reflected where? Have you seen the LCR?
Yes, Lordship.
It is reflected.
Yes, Lordship. But Lordship,
because if that is correct, then you see the quantity will come down.
Yes, but the thing is that
correct. So then the record of 37 goes.
Lordship, at this stage, because the informant is yet to be.
That is a different matter. You see, I'm not convicting the person.
Yes.
Right. This is a question about a trial.
Yes.
The bail.
Yes.
Now here, because of 37 regard, this court had earlier rejected.
Yes, Lordship.
Now suppose this it comes down.
Yes.
If you deduct the weight of the drum,
yes,
then perhaps that C goes away.
Lordship.
Correct.
May I
It will
submit?
come down under the commercial quantity.
Yes.
Then
Lordship, may I submit, Lordship?
Yes.
This drum is also substituted by the word container. Lordship, kindly come to page 22.
Of the petition.
Yes, of the petition. Paragraph 5, Lordship. It starts from.
Weighing 720 grams.
Yes, Lordship, at 10:30 p.m. It starts from. Paragraph 22 of the petition. Paragraph 5, Lordship.
Yes.
Has it, Lordship, got it?
Yes, I've got it.
Yes, Lordship, that at 10:30 p.m. on being led by Aziz and apprehended Aradhan Burman left
Container.
so and so and conducted.
Right.
Yes, Lordship.
Okay.
Container is
Fine.
also included.
Fine.
Yes.
Page 27.
Yes.
Page 27 is the seizure list.
Per contra, MS so-and-so learned APP, by drawing attention of the court to the charge sheet. This is part of the charge sheet.
No, Lordship, FIR.
To the FIR.
Yes.
She states that it is clearly alleged that at 10:30 p.m. upon apprehending the accused, the team recovered one blue color plastic container within bracket drum containing suspected contraband articles.
Yes.
Stop. And stop. She further submits that the matter that the said fact being a matter of she further submits that the said being a matter of fact which has to be ascertained at the time of trial ought not be a ground for releasing the petitioner on bail.
Yes.
Stop. I have given my prudent considerations to the arguments made by the learned counsels of both parties and have perused the materials available on record, including the scanned copy of the case records. Pertinent that this court earlier by order dated 19/12/2023 had rejected the bail application of the petitioner primarily on the ground that the contraband articles have been recovered from the possession of the accused person and that the accused person is involved in illegal business of selling contraband articles and that the accused person has been arrested earlier in connection with PGR PSC number 72 of 2022 and charge sheeted by CS number 55 of 2022 dated 24/7/2022. Stop. There appears no change of circumstances warranting grant of bail as sought for. Further, it appears that trial has commenced. So, accordingly, the bail application stands rejected at this stage.
Highly obliged, Lordship.
All right.
itu আরামে মনে আসলে তো